as infractors.
Deeply. Lordship, I beg to mention item
Mr.
number-
Chuti IPS for the respondents. Yes.
Lordship, I beg to mention item number 24, not before my lord. Lordship. 24.
Item 24 before any other bench.
Highly obliged.
May please, your lordship. With the consent of other side, my lord, I beg to mention item number 50 and 51, my lord. May be taken up, my lord, after.
50, 51
My lord.
to be listed after vacations. As prayed for by Mr. R. Sharma, counsel for the petition. Yes.
May please, your lordship. I beg to mention item 2 and 3, your lordship. The matter for urgent for the day, your lordship.
2 and 3 after vacation, as prayed for.
Fix a date, your lordship.
After vacation, you make a mention.
Lordship, in that case, Lordship, that instead of taking the IL, Lordship can take the entire repetition for disposal.
We don't know. Who's filed the IA?
My learned friend has filed that.
I have felt that.
You are the sitting Gavuda. You are appointed.
Lordship.
Your appointment is state
Yes, state, your lordship. I have held.
by him. So we can, whatever you say, you want to take it up today or after vacation? After vacation. 16, 17 November.
17.
May please, your lordship. Lordship, I beg to mention item 36 of today's list.
36.
36, orders matter, lordship. We could not file the amended cost item, lordship, in time. Let it come after vacation.
You're for
I am for the petitioners, lordship.
Mr.
D. Deka.
D. Decca, learned counsel for the petitioner submits. The amended post title could not be filed. Matter will be listed after 2 weeks.
I'm highly
Yes.
obliged, lordship.
May it please your lordship. Lordship, I beg to make a mention of item number 48.
48.
Yes, your lordship. In this case, the connected read petition which has been tagged with is the wrong file.
876.
Yes, your lordship. It should have been 876 of 2022, not 2020.
Okay. It is submitted by MS M. Kechi, learned counsel for the
Petitioner.
petitioner in the contempt petition that the connected writ petition has been wrongly listed. The correct number of the writ petition would be WPC 876 of 2022. Accordingly, registry to rectify and list the matter again after 2 weeks.
Obliged.
Yeah. I'm for the respondent.
Mr. Dr. APS for the respondent. Yes.
Deeply obliged.
May please, your lord. Lordship, I beg to mention item number 47, Lordship. Yeah, the order is complied, Lordship, and the matter is infraction.
It is submitted by Mr. H. Talukdar that the directions contained in the order dated so and so passed in WPC so and so has since been complied with. Therefore, he does not wish to press the contempt petition any further. Accordingly, taking into consideration the submissions made by the counsel of the petitioner, contempt petition stands closed. Notices issued are withdrawn, are recalled. Yes.
May it please, Lordship. Lordship, I am praying for adjournment of item number 41, Lordship. In
41.
this case, the opposite party filed one affidavit. We have taken instruction from the party, Lordship.
Mr.
R. Sharma.
You are for?
I am for the petitioner.
Mr. R. Sharma for the petitioner prays for and is granted 3 weeks time to file rejoinder affidavit to the affidavit filed by the respondents. Matter stands adjourned for 3 weeks.
May please, your lordship. I beg to, with the consent of other party, I beg to mention item number 7, my lord. This matter may will listed after vacation, my lord.
Who's for the petitioner?
My lord, I am for the petition. May I please?
Yes.
My lord, this was a matter where there was a direction to produce the mark sheet of the apprenticeship that issue, my lord. Though they are not able to produce it today, they are taking some time.
The communication has been made by the.
Mr. Dr. Learned, A.K. Dr. Learned Counsel appearing for the railways prays for and is granted 2 weeks further time to comply with the directions of the orders of the court. ID order dated so and so passed earlier. Mr.
K. Vishwakarma, my lord.
K. Vishwakarma appears for the petitioner.
My lord, a date may be fixed, my lord, so that
No date fix. We had fixed it today. If a matter goes out of the roster, it will come back
We have-
and fix a date later.
Now we have decided to send a person, my lord, to collect the.
Yes, very nice.
obliged.
Please.
Item number 33, my lord. It's a contempt matter. The direction was to consider her case for promotion. to the post of Director of Historical and Antiquarian Studies. Now she has retired in the meantime, and so my lord,
It is submitted by Mr. Bharadwaj. P. Bharadwaj, that the petitioner has retired in the meantime. Therefore, she does not wish to press the contempt petition any further. But the order has not been complied with.
that is true, my lord. Even she has not taken the dusty service ordered by this court.
She does not wish to pursue the contempt petition accordingly. The contempt petition stands closed, taking into consideration the submissions made by the learned counsel for the petition. Notices issued are recalled. Yes.
Made praise of lordship, I would like to mention item number 22 on behalf of Mr. Senior Counsel P.D. Nair. He is out of station and we have taken the consent from the other side.
Yes, anyone?
Lordship, I am for respondent number 6 and 7.
Yes. No objections?
Do you have any?
No, Lordship.
At the request of learned counsel, MS so and so, matter stands adjourned for 2 weeks.
Highly obliged.
Obliged, Lordship.
May I please,
My lord.
Counsel for the respondent does not object. Yes.
item number, I want to mention, item number 21, Mr. Dilip Borua is not well. Going to pass over.
Item 21, it is submitted that Mr. D. Borua, learned counsel to the petitioner, is indisposed. Adjournment is sought for on his behalf. Accordingly, prayer is allowed list after 2 weeks.
I'm
Yes.
for the respondent, lordship.
Mr. Roy appears for the respondent.
Yes, your lordship. I beg to mention for listing of an unlisted matter for withdrawal for today, lordship.
Unlisted for today. Why do it
For
on Monday?
withdrawal, lordship.
Do it on Monday? Will it be listed today?
Yes, lord.
See if it can be listed. All right.
May-
You give it to the court master. Let us see if it comes. Yes.
Wait, please, your lordship. Lordship, I beg to mention item number 28 kindly be taken up at 2, lordship.
Why?
Lordship,
The court may not be available that long.
before
If we complete the list, we complete.
last item then. lordship.
Last item, at the end of the list, item
Yes.
28. Yes.
Highly obliged.
No, please, your lordship. I beg to mention item number 43, my lord.
Hmm.
The matter may be adjourned for week, my lord.
Why?
In this matter, my lord, I have to file a substitution petition of the respondent. Already I have submitted the.
You are for
I am for the petitioner, my lord.
Mr.
M.A.I. Hussain.
M.A.I. Hussain submits that you'd like to file what? Supplementary affidavit.
Substitution
Rejoinder.
of the respondent. Substitution of the respondent.
Substitution of the respondents. With substitution for what? Somebody expired.
My lord, they are already transferred from other post, my lord.
It's not substitution. Implementation of
My lord.
the respondent. He prays for 2 weeks' time, prayer allowed. List after 2 weeks. Yes.
May I please, Lordship? Lordship, I beg to mention item number 25. We have already taken consent of the other side.
Why you want to mention?
In this case, learned engaged counsel is not well for it.
Who is the engaged counsel?
R. Sinha.
Mr. R. Sinha, learned counsel for the petitioner is stated to be indisposed. Matter stands adjourned for
Matter
2
may be
weeks.
taken up after 4 weeks.
After 2 weeks, yes.
Interim may be continued. Interim may be.
If it is there, it will continue. Yes. Yes, yes, yes.
My lord, I beg to mention item number 10. Mrs. Hesbera is personal difficulty. So the
Item
may
10,
be-
at the request of Mr.
Mrs.
Your name,
No,
your name,
Pranjal Bora.
P. Bora. Matter stands adjourned
I'm for the
for 2
respondent.
weeks. Mr. Roy appears for the respondent. Yes, yes.
My lord, I beg to mention item number 34, my lord. My lord, matter may very close, my lord, because matter has become infractious. Because writ appeal already allowed, my lord. So, my lord, matter.
What is, do you have the number of the writ appeal?
Yes, my
Order?
lord, writ appeal number 256/18. And dispose of on 3/8/23.
Setting aside with the order of the learned single
Yes,
judge,
my lord.
interfering.
Yeah, my lord. Yes, my lord.
It is submitted by Mr. H. Das, item 34. That the order of the learned single judge, the directions contained in the order of the learned single judge for non-compliance of which the contempt petition was filed, has in the meantime been altered in an appeal, intra-court appeal, being writ appeal 256 of 2018, whereby the division bench by order dated 3/8/2023 has interfered with the findings of the learned single judge. That view of the matter, the contempt petition stands closed.
I will ask, my lord.
Notice is issued. Recall. Yes.
May I please, Lordship? Lordship, I beg to mention a writ petition for urgent listing. Lordship. Matter is
Monday, Tuesday,
Monday.
Monday. Urgent listing for what?
Lordship, it's a because it's a transfer matter. Transfer of writ petition and duty abolition of all divisional commissioner officers.
When was it filed?
Lordship, on 12. On 12, 12/10.
All right. Monday.
Of like Lordship.
May please allow. Lordship, I have instruction from the client to withdraw that.
As per the submission of Mr. P. Das, learned counsel for the petitioner, who submits that as per instructions, the petitioner does not wish to press the writ petition any further. Same accordingly stands dismissed on withdrawal. Interim order, if any, stands vacated.
I'm obliged. In this case, Mr. Dinath is coming, your lordship, just 5-10 minutes.
We have given you adjournments, now you're asking for accommodation.
Accommodation, your lordship. He's on legs in court 1, your lordship. So that.
All right, Mr. Monto,
My lord,
for the time being,
let him
we'll
come.
take it up after some time.
Yes, let him come immediately
Yes.
on his arrival.
Yes. Yes,
My lord.
yes.
Incumbent, my lord,
Hmm.
recently. I have intimated him, my lord,
Who?
both the chief engineer, irrigation department and executive engineer.
You want to implement now?
Yes,
Executive engineer.
That's for
Chief
number
engineer.
3 and 4, my lord.
Heard Mr. J. Sharma, learned counsel for the applicant. This application is filed for implement of the new incumbents to the posts of chief engineer and executive engineer, namely three. In Namtu Sailova, 3 and 4. KMG Sane Rajkumar and Mr. Niranjan Das, respectively. Stop. The submission of the learned counsel is that the opposite party in the IA are presently holding, are presently the incumbents in the post of chief engineer irrigation department, Government of Assam, Chanmari Guwahati 3, and executive engineer irrigation department, Moholdoi irrigation division, respectively. Stop. The learned counsel submits that it is necessary to implement them as in the content petition number 339 of 2021 as the directions contained in the order dated so-and-so passed in WP so-and-so has not yet been complied with. Considering the submissions made by the counsel for the parties and upon perusal of the IA, this court finds it appropriate to allow the IA without issuance of notice for implement of the respondents 3 and 4. Anyone for irrigation?
No, my lord.
In
I'll
that,
take steps. my lord.
in view of the order passed, Sri so-and-so and so-and-so are arrayed as respondents number 3 and 4 in contempt petition number 339 of 2021. The IA accordingly stands allowed. Petitioner applicant will file amended course title within a period of 1 week from today before the registry. In contempt petition number so-and-so, in view of the order passed in IA, so-and-so are arrayed as respondents 3 and 4. Petitioner is directed to file amended post title before the registry within 1 week from the date of the order. Matter be listed after 2 weeks.
Okay.
Promotion.
Lordship, Lordship on the last occasion, Lordship directed me to take instruction. Lordship, I have communicated, but I have not received a short time, Lordship.
What short time now, the vacations are ensuing. This man's
Yes, Lordship.
condition to be considered position.
Lordship, dispose of it.
In the absence of the counsel for the petitioner. No, we can't dispose of unless you come up with a specific
Yes, Lordship.
stand as to what is to be done. We fix it on Tuesday, you tell us.
Yes.
List on Tuesday. Enabling Mr. P. Chaudhary to obtain the required instructions in the matter. In terms of the earlier order dated 25/9/2023 passed by this court.
Okay.
List on Tuesday, 17th. Yes. No amendment filed?
Lordship filed, we have filed lordship, but that is not tagged with the record. Lordship.
It is submitted by the learned counsel for the petitioner that the amendment petition is permitted to be filed by this court by the earlier order dated 6/10/2023 was filed on
On 11 lordship, 11/10/23,
11/10/2023.
2020.
Stop registry to, have you received copies of amended petition?
Even then, my lord, written copy I also not received. As because my lord, in
Counsel.
2015, my lord, there is no standing council.
Learned counsel for the respondents, Mr.
One lordship.
J. Hendick. Respondent 1, Mr. Sutia for
I am for 2, 3, 4. And
3,
5.
4.
lordship.
Submits that they have not received copies of the amended writ petition. Stop petitioner is directed to serve copies of the amended writ petition during the course of the day. And the registry to verify and trace out the amended writ petition stated to have been filed and connect it to the case record matter to be listed
Lordship,
in
my
the
lord,
first week of November.
our name may be reflected in the my lord,
Names of the respective
revenue
government
department.
councils
SC
be
revenue.
reflected in the cause list.
Obliged.
Yes,
Lordship, on the last occasion, counsel for DLC was asked to produce records. I miss.
where are you appearing from?
P-
We have received instructions regarding DLC minutes.
What do the instructions say?
My lord, I will have to go through it, my lord. It is on
All right, Monday,
Monday, my lord. I will go
Monday?
through.
Monday. It is submitted by Mr. P.C. Sutia that the instructions sought for have been received. Accordingly, matter be listed on Monday.
Obliged.
It will withdraw corridors. In fact, item 9. Yes, who's for the Union of India? Union? You're appearing for this matter?
petitioner lordship.
Petitioner, yes.
Lordship, this matter has become infructuous lordship. We would like to withdraw this petition.
MS so and so learned counsel for the petitioner submitted the matter has become infructuous. None appears for the union. On taking note of taking into consideration the submissions made, the writ petition stands dismissed as infructuous.
Lordship, Ovilas lordship.
He wants some time to, not you, he wants some time to go through the records, so we fixed it on Monday. Monday.
My lord.
Writ petition dismissed as infructuous. None appears for the petitioner on call. None had appeared for the petitioner earlier when the matter was called on 3008-2023, 2509-2023. Accordingly, writ petition stands dismissed for default. Interim order, if any, stands vacated. Yes.
Lordship, affidavit has been filed, Your Lordship, but by the SP. In this case, there is a discrepancy of the date of birth, Your Lordship. The SP is basically espousing the cause of the law, it's basically taking the same stand as the petitioner, Your Lordship. But one or two things are there. He has basically talked about the fact that it has come, that the direction has come from the departmental headquarters, Your Lordship, the Assam Police headquarters, Your Lordship. So that affidavit or instructions I don't have, Your Lordship. If Your Lordship gives me time, short date, I'll try to get the instruction from the headquarters why they decided to retire him 5 months early, Your Lordship.
But he's already completed. Now the question.
Lordship, he is
So
already
now the
completed.
question is whether that period of service is he entitled to
Lordship,
for any financial benefit.
Lordship. On the last occasion also, Your Lordship has.
So
said
that
the
will
same.
require a decision in the matter.
Lordship.
This will have to be decided.
Lordship, yes, absolutely. That is what Your Lordship had also earlier, the last occasion also, Your Lordship.
None appears for the petitioner on call. Mr. C.S. Hazarika appears for the respondents. It is submitted that you are appearing?
My lord, item number 13, my lord. I am appearing, my lord.
Yes.
My lord, yesterday, my lord, I received the affidavit in opposition, my lord. I need some time to take
All right.
instructions.
Mr. Bora,
M. Dr. my lord.
M. Dr. Learned Counsel for the petitioner submits that. What affidavit? You filed some affidavit?
Yes, Your Lordship. Yesterday it was filed, Your Lordship.
Oh, okay. It's not here. Filed by whom?
SP, Your Lordship. SP.
SP. Earlier there was no affidavit filed.
No affidavit filed. The Lordship had granted some.
Okay, it is submitted by Mr. C.S. Hazarika that an affidavit has been filed on behalf of the SP. Yesterday. Stop. The same, however, is not available in the case record. Mr. Dr. Learned Counsel appearing for the petitioner submits that he has received a copy and would like to file a rejoinder affidavit. Accordingly, matter stands adjourned. Matter be listed after 2 weeks. Registry to trace out the affidavit stated to have been filed by the respondents and connect it to the case records. List after 2 weeks.
Obliged.
The 18 meter. No, not. No, 14.
regarding regular pension.
None appears for the petitioner on call. None had appeared for the petitioner on 28/8/2023 as well as on 8/9/2023. Of the claim of the petitioner is the prayer of the petitioner before this court is for a direction to provide regular pension scheme for the retirement benefits to the petitioner, as the petitioner had rendered services as master role workers.
RH is got the pension, that's why you got it.
Hmm? You get the instruction? Uh, So accordingly, Mr. Chutia Learned Counsel, Additional Senior Government Advocate, will obtain instructions as to whether the claim of the petitioner has been redressed by the department concerned, namely the Department of Geology and Mining. List after 2 weeks, by which time the learned senior government advocate will obtain the instructions and place it before the court. Copy of this order be marked to the office of the learned senior government advocate to enable him for taking necessary steps in terms of the directions issued. Please
Bless
get
you.
the instructions and place it in the
Yes.
for the court. Yes,
We have received instruction in this case, my lord.
what is that?
The earlier advertisement that was cancelled.
Hmm.
And due to my lord, cancel and press advertisement was made. Press advertisement was also issued by letter dated 7/5/2018 of circle officer. So and so, circle officer.
Did he
so-
participate?
I don't know, my lord. On the basis of press guideline, that was the guideline it defined. Now age is 30 to 65, minimum 30. And at that moment, Bala, that was wrongly they have advertised. I think, however, both the petitioner did not apply against the, oh yes, not apply
Subsequently.
subsequently. However, both the petitioner did not apply against the fresh advertisement. Lordship can have it, my lord. The press advertisement was issued as per latest notification 2018. Since the matter was sub judice, the interview of the Gambu Pradhan post of both how, where Gambu and so and so.
All right, none appears for the petitioner on call. None had appeared for the petitioner earlier on 30/08/2023 as well as on 9/10/2023. That be the matter. The petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated. Mr. Sutia appears for respondent so and so, Mr. Hendrik for respondent 1.
Highly obliged. Please, election. So this is the matter of restriction of.
Sweepers. Sweepers.
Yes,
Yes.
they have filed one affidavit yesterday. I do not know it is there in the record.
What affidavit?
Your lordship, in connection to the additional affidavit filed by the writ petitioner. Yesterday we have filed your lordship.
Yesterday, if your file, it will not be here.
Your lordship may kindly be taken up on Monday if possible, your lordship.
Monday. We'll have it after vacation. Or you want it on the Monday? Monday, because last few days, may not be possible to give a proper hearing in the matter. That is the only anxiety.
The thing is, my lord, it's well, they were aware, they ought to have filed the affidavit earlier.
They ought to have filed,
Filed
they did
it
not
at the
file.
last moment and has served a copy on me at 2:30. My lord, I just take my chance on Tuesday, my lord.
Or we'll have it immediately on the reopening, 6th, 7th, 8th, whatever date you want.
Or if it is otherwise not inconvenient, can it be on Tuesday? We'll take a chance if possible on Tuesday, otherwise it will go.
17th, all right. List on 17th, it is submitted that by Mr. M. Sharma, learned counsel for the bank, that an affidavit in reply. What affidavit?
Yes, sir. Reply to additional
Reply
affidavit
to
filed
the
by the
additional
petitioner.
affidavit filed with the petitioner. It was filed yesterday. The same, however, is not available in the case record. Registry to trace out and connect the same to the case records and list the matter again on Tuesday.
17th.
Better to have it in November because this will require some hearing, which may not be possible on Tuesday.
I leave it to
We
you.
are being candid with you.
I leave it to your lordship.
So list again on 6th of 7th of November
But 7th,
or any other date.
7th, I have some matters in.
All right, you tell us a date.
9th.
9th November. All right, 9th November. List on 9th November.
May I please, sir?
Yes.
This matter may be timing.
No timing today. Why timing?
Possibly. In this case, NK Muri is, he's coming, Lord, he's just
No timing today.
next item, Lord. Last.
Oh, he's here.
Oh, yeah.
I'm sorry, my lord.
Yes, yes, tell us. Yes, please.
Basically, my lord, this petition has been filed, my lord. The appointment which has been made, my lord, on compassionate ground, my lord, that has been made temporary ad hoc, my lord. And
Where is your appointment order?
my lord will find my appointment letter at page 31, annexer. No, annexer 3, page 33, my lord. No, sorry, my lord, annexer 2C, page 31.
This is pursuant to DLC, SLC. Some order was passed.
My lord, nothing shows, my lord, but on date of
Was
my
your case
husband,
considered by DLC, SLC?
earlier there was no such DLC, my lord. It was, order was in the year 1990, my lord.
Okay. But I think there was a memorandum of
Of course, my lord.
1983. Yes. Why has she been appointed in a temporary post? Who's appearing for the respondents? Executive Engineer
I
PWD.
need some time, my lord. I have some instructions I received, my lord. Immediately after vacation, I will file affidavit, my lord. I have some-
Your affidavit is not important. What is there in the instructions is important. What is it? Why have you appointed
but
her
this is,
in a temporary
instructions-
post?
Instruction, my lord, India year 2018 instruction, my lord.
Huh?
2018 instruction, my lord.
You have
But I think
realized
my
it
lord-
now. You
No,
came to be aware of the instructions now.
Now, my lord. My lord, earlier, my lord, Kaushik K. Goswami is handling the case, my lord. Now, my lord, I am newly appointed in this figure.
You were newly appointed for quite some time. Not yesterday.
This file was received yesterday also.
Oh.
After, immediately after vacation, my lord, I take order.
Is she working?
Yes, my lord.
She's working on a fixed pay.
Now, my lord, fixed pay per on record, my lord. It
Miss-
appears, my lord.
Mr. Murray, N.K. Murray appears, take down. Mr. Murray appears for the petitioner, Mr. Conicor appears for the
3, 4, 7, and 8.
3, 4,
7 and 8.
7 and 8. It is submitted that it is submitted that the learned council for the, what is that? Karbi Anglong,
No, Dima Hasao.
Dima Hasao.
NC Hills Autonomous Council.
NC Hills Autonomous Council has received instructions and like to file an affidavit. He prays for some time. Mr. Hazarika appears for
1 to 5.
1,
1, 2, 5 and 6.
1, 2, 5 and 6. Matter be listed after 2 weeks. That's prayed for.
Also,
Obliged,
just
obliged.
one second also. 1 to 5 and 6 is possibly wrong on my part, your lordship, because at that time the PWD was there. Right now,
You appear for 1.
only for 5, your lord. Otherwise, PWD is there for
And
1,
only for 5.
2.
Yes. All right.
Obliged, my lord.
Diplo.
Yes.
Mr. Lordship. Lordship, my senior Mr. A. Sharma is on left.
The counsel for the petitioner. This is that case of disappearing.
Yes, Lordship.
All right, we pass it over for the time being. Let the
Okay.
petitioner come. Time being.
Much.
May it please your lordship. Well, I am appearing on behalf of Mr. H.K. Raj, standing counsel. My lord, this matter pertains to a recruitment of post of an office peon on temporary basis, my lord.
Yes.
As per the instruction of the registry, my lord, his appointment and continuation was subject to favorable police report. But my lord, he has been arrested on the basis of an FIR, my lord. He was found to be an NSTN cadre and ammunition was found with him. And my lord, I have the status report of that case, my lord, which is pending before the
You bring it on record. You
by an
bring-
affidavit.
By an affidavit.
He has been convicted, my lord.
You bring it on record.
My lord.
None appears for the petitioner. Mr.
No, I am U Pathak. I am
U.
appearing for
Pathak.
H.K. Das.
appearing on behalf of Mr. H.K. Das submits that instructions have been received. And he'd like to bring it on record by way of an affidavit.
My lord. I'm obliged.
Yes.
In this case, we have already filed all.
Affidavit has been filed.
Yes, my lord.
You want to file any rejoinder or?
No, my lord.
All right. What is the issue about?
In affidavit, my lord,
Uh,
the selection process, the allegation against the selection process, they denied, my lord. But one thing admitted, my lord, ACP benefit, my lord, that he have get at least 3, my lord, and the respondent given only 2 benefit, my lord. In affidavit, paragraph 11 and paragraph 13, they admitted, my lord. And petitioner retired, my lord, in the year 2020. Kindly consider paragraph 11 and paragraph 13 of the article. He already retired, my lord, so I not challenge anything, my lord. Only I pray, my lord.
11 and 13.
MSP benefit. my lord. Yes, ma'am.
Yes, what is there? Please read.
Para 11, my lord, they are repetitive, my lord.
You did not submit applications.
No, my lord, I retired 20, my lord. They made advertisement 21, my lord.
Okay.
That's what they are. So I may allow to file application, my lord. Bring the.
Whether after retirement, whether he's entitled on that is a.
When was it implemented with effect from 2017? This is from 2017, MSCP?
Yes, my lord. It says that it was introduced with effect from 1/1/2017, my lord.
2017.
But the order was issued on application was invited on 29/2021.
So why was it not issued earlier prior to his retirement?
There. But I don't have this instruction, my lord. That
So
is
he is
what-
entitled to be considered.
Yes, then naturally, if he applies, my lord, that will consider that.
So let him apply.
Yes, let him apply. On merit, my lord, whether he's entitled, we don't know about the
No,
scheme.
no merit. If merit is to be decided, we'll decide it.
Yes. No, whether as part of the scheme, whether he's entitled, that will then
So where is the scheme?
scheme is, because that was not a prayer in the writ petition, because they have come,
Yes, prayer, my lord. Last in my prayer, my lord.
basically he is against the private respondents, my lord, selection of
Kindly,
the private.
kindly see, my lord, my prayer.
Anyway, my lord, since he's retired, my lord, let him file an
Last
application,
motion,
my
my
lord.
lord.
We heard learned counsel for the parties. This petition is filed with the petitioner who was appointed. You were appointed in grade 3
Grade 4, my lord.
Grade 4.
Laboratory attendant.
and grade 4 under the Assam Agriculture University. Stop. Petitioner put to challenge by the writ petition the promotional orders issued to private respondents 4 to 7, 4, 5, 6, 7 for promotion to the post of grade 3, overlooking the claim of the petitioner. Stop. Further prayer was to grant all benefits, including benefits of MSCP. Stop. The grievance of the petitioner is that although he satisfied all the criteria, his case was overlooked by the petitioners, by the department, and private respondents 4, 5, 6, 7 were considered overlooking his claim. Stop. While the writ petition was pending, the university filed their affidavit on 27/9/2023. In para 10, para 11,
11 and 13.
11 and 13. The following amendments are made. Extract 11 and 13. Stop. Para learned counsel for the petitioner submits that it is admitted by the respondents that the MSCP scheme,
MSc, Modified Assured Career Progression.
MSCP scheme was with effect from was implemented with effect from 1/1/2017. Although the applications were invited on 2009/2021. ID memo number so and so, paragraph 11. Stop. However, the petitioner came to be superannuated on 31/07/2020. Stop. Para Learned Counsel for the petitioner submits that although his writ petition, although in his writ petition, his prayer was for setting aside and interfering with the promotions granted to respondents 4, 5, 6, 7, considering the fact that he is in the meanwhile superannuated on 31/07/2020, and also taking note of the averments made in para 11 of the said affidavit that the MSCP scheme was implemented with effect from 1/1/2017. The petitioner be permitted to approach the authorities and apply, make necessary applications for getting the benefits under the MSCP scheme. Which ought to have been implemented while the petitioner was in service. Stop. Mr. Kotoki Learned Standing Counsel for the university does not object to the prayers made. Accordingly, the writ petition stands closed, permitting the petitioner to approach the authority, namely the Agricultural University,
Registrar, my lord.
Registrar Agricultural University, to and make necessary applications for release of for consideration and release of his benefits under the MSCP scheme, which was stated to have been implemented with effect from 1/1/2017, which is well prior to the date of superannuation of the petitioner. Stop. As discussed above, petitioner, as referred above, petitioner superannuated on 31/07/2020. The petitioner will, if the petitioner files any application as permitted by this court, the authorities will consider the prayer made by the petitioner for release of the benefits under the MSCP scheme, which was implemented with effect from 1/1/2017. Stop. The competent authority will thereafter pass appropriate speaking order and release whatever benefits are due to the petitioner within a period of 60 days from the date of 30 days or 60 days? 30 days from the date of receipt of the application, along with a certified copy of this order. The petition accordingly stands disposed of in terms of the above. Item 27, as per the adjournment slip circulated, matter stands adjourned for 2 weeks. This is the last item. Hold up as the last item. 28 will be called up as the last item. Yes. Yes, Mr. Goswami.
This is selection and appointment to the post of revenue solicitor
My
in
lord,
the district of Nalbari.
before my lord needs senior start, my lord, we could not communicate, my lord, the client, my lord, so we could not file our affidavit. One chance will be given, my lord.
Lordship, in this particular case, from long back, Lordship has fixed this matter for disposal.
Or
And
it may be
earlier occasion,
fixed
they
for
have
my
not
lord,
appeared.
hearing after vacation, my lord. In the meantime, if we,
On last occasion, Lordship, they have said they have not received affidavit. Now they are saying that they are going to file affidavit with cost, Lordship. Otherwise, Lordship, I have to explain my client, Lordship, because he is going to return on December. Intention behind is to delay the matter, but somehow I have to repair.
You are appearing for whom?
Private respondent.
private respondent, my lord.
So you are what? You are
I-
already promoted.
Record is
Promoted.
already there, Lordship.
Promoted, my lord, that too, my lord, after direction of this our court, my lord.
Hmm. Where is the direction?
There is a writ petition earlier, my lord. Earlier, 2 writ petitions were filed, my lord.
Where is
And
the order?
one petition is pending WBC 4969.
No. Where is the direction pursuant? to-
Direction, my lord,
Same post play.
কি order?
এটাই সিলেকশন পেন্ডিং হয়ে ছিল
Selection হবো লাগে।
What is your name? The petitioner.
উমেশ চন্দ্র দাস my lord.
He is a respondent here.
Direction to hold the selection process. Not to.
And on the basis of direction my lord, selection conducted and appointed.
And I am not a party to that.
That is only for direction to conduct the selection, not to appoint you. You are appointed. Yeah, what is the stand of the department?
Lordship, my case is like this. Lordship. The selection should be held on the basis of merit, as per notification issued by the department as well as the Assam Ministerial District Service Code. Here, Lordship, the admittedly from the record, the DC affidavit from the Deputy Commissioner also said, the GAD also said that merit has not been assessed. Kindly see. Kindly see, Lordship, circular page 20, Lordship. Page 20 of the requisition and Annexure 4.
Yeah.
Lordship, this is a circular issued by the GAD to the Deputy Commissioner, all Deputy Commissioner. Now, Lordship will find last paragraph. The concerned commissioner division strictly on merit for appointment the post of revenue solicitor. Last portion, Lordship. Commissioner of the divisions strictly on merit for appointment to the post of revenue solicitor or head assistant in amalgamated establishment of deputy commissioner in the district. His subdivisional shall, on the basis of assessment of annual confidential reports of every eligible candidate, other relevant service record, not any other basis such as interview or viva voice. Now, Lordship will consider only the merit. Record is there, Lordship. GAD is there. And their affidavit, Lordship will find affidavit at page. Lordship will kindly see page 38. Affidavit of the Lordship, respondent number 3.
Yes.
Page 38. Para 12. With regard to the statements made in paragraph number 14 of the writ petition, deponent beg to state that from the minutes of the selection board of the writ petition, it does not appear that an exercise was undertaken regarding ACR and other service to particulars of the candidate.
It does, it does appear.
It does appear that an exercise was undertaken regarding ACR and other service particulars of the candidate. This is the stand. Now,
You are reading from which paragraph?
Page
Lordship, we can
37.
para 12, page 31, 37.
37.
Lordship.
Whose affidavit is this?
This is Deputy Commissioner Secretary,
Or Deputy Commissioner?
Nalbari, Lordship, where the post was to fill up.
37 is is a part of the affidavit filed by Joint Secretary GAD in this copy, in the court's copy.
I have been served a copy, Lordship, Deputy Commissioner's affidavit, Priyanka Kashyap.
Yes. Para 12.
Para 12.
Who heads the selection committee?
Selection committee is to be conducted by the GAD, Lordship. I will place that.
Who are the members of the committee?
The member of the committee is Lordship will find at page.
So they say that an exercise was undertaken.
Undertaken. Now, Lordship, that is why, Lordship, I'll place the relevant portion where from they have assessed the merit. Kindly see This is the minutes of the selection committee, page 31 of the repetition.
Yes,
This is the minutes, Lordship, by which the Umesh Chandra Das private respondent has been recommended for promotion to the post of revenue solicitor. Last portion. There is no finding that merit has been assessed.
what are the rules? What do the rules say? Rules of
That is well.
rules. Ministerial service rules.
Rule I have annexed at page 12. Lordship.
Which rules are applicable?
Assam Ministerial District Establishment Service Rule,
67.
67, 99. Amended to 99. From page 13. Appointing authority means secretary to the government of Assam. Section 2, 1A. Secretary to the government of Assam, General Administrative Department, in the case of appointment to the post of revenue solicitor. Now,
You are referring to page number
page number 13.
13. Yes.
Two, one. Appointing authority means secretary to the government of Assam General Administrative Department in the case of appointment to the post of revenue solicitor. Thereafter, Lordship will find page 14.
Yes.
For the purpose of selection, there shall be selection board consisting of following members. Secretary to the government of Assam General Administrative Department, Chairman. Page 14.
Yes.
Commission of the Lower Division, member. DC of the concerned division, member. Deputy Secretary, Government of Assam, General Administrative Department, member secretary. Thereafter, also, appointing authority shall advertise the vacancy, inviting application from suitable person fulfilling the requirement of the post of appointing authority concerned, shall obtain annual confidential report for last 5 years, consecutive years, and relevant service particulars of eligible person for recruitment to the cadre of revenue solicitor, and shall furnish to the selection board annual confidential report and other relevant service particulars of the eligible person along with approximate number of vacancies likely to occur during year. Board shall examine the annual confidential report and relevant particulars of the person, taking into consideration the merit of the person, and prepare a list members in preference for recruitment. So merit is the only criteria. And thereafter, Lordship, advertisement at page 16. Page 16 is the advertisement. There is another criteria. The person should work in the revenue branch in particular. Page 16, dated 5/7/19.
Yes.
Applications are invited prescribed for the post of revenue solicitor in the amalgamated establishment of Deputy Commissioner Nolbari in the Peben Iman as per provision of Assam Service ROP Rule 17 under Assam Ministry District Assessment 1967 as amended. Candidates must have served at least 15 years in the Deputy Commissioner establishment of Assam and experience in different branch in general and revenue branch in particular. In this particular case, I have taken two stand. The person who has been appointed, he has not worked in the revenue branch, and as well as merit has not been considered. Thereafter, Lordship, the circular issued by I have already placed page 20, that merit is the only criteria. Page 20. The circular issued by General Administrative Department.
Yes. Where are the minutes again?
Minutes. Minutes at page 31. Selection also error, Lordship, because member was not present, relevant member also not present. Page 31.
Yes.
Secretary Government of Assam Chairman, Deputy Commissioner member, authorized officer of Divisional Commissioner Lower Assam Division. He become a member. He cannot be a member. Under Secretary Government of Assam Member Secretary, General Administrative Department. That is also Lordship, this selection is goal on the basis of authorized officer of the Divisional Commissioner. How can he authorize? There is no provision to authorize any other person. Chairman welcome the selection board. Official request the member secretary to furnish the comparative statement of ACR and candidates relevant service particular of the candidate. Member secretary, in addition to the above particulars, inform the board the post of revenue solicitor under amalgamated establishment of Deputy Commissioner Nalbari is lone post in the cadre and post to be filled up by of selection from amongst the candidates who have completed 15 years of service on the date of advertisement as per rule of Assam Ministerial District Service Rule 1967. Board examine the comparative statement of ACR of the candidate and other relevant service particulars of the candidate as submitted in the proposal from Office of the Deputy Commissioner Nalbari. Since the post of revenue solicitor amalgamation of Deputy Commissioner Nalbari single post cadre, hence reservation of roster point in case of selection and appointment is not applicable as per Assam SC/ST Act 2012. No department proceeding and court case is pending against the selected candidates as stated in the proposal. After the State Board discussion, board with reference to the Rule 6.1, Assam Ministerial District Service Rule 1967, Assam Ministerial District Establishment Service Amendment Rules 1999, decided to recommend name of Umesh Chandra Das. Now, Lordship, I will produce the forwarding report of the ACR. Kindly see the forwarding report of the ACR. Page 26 is the forwarding. Page 27 is the Lordship, the statement of ACR of last 5 years forwarded by the Deputy Commissioner. Page 27.
Yes.
Page 29 will be very limited. Page 29 is a comparative statement.
Yes.
Lordship, initially is Umesh Chandra Das, who has been appointed. Now, Lordship, the 5 years ACS is necessary. 2014-15, good. Umesh Das. I am Lordship, 2014-14, very good. 2015-16, good. Myself, Bhubaneswar, next one, very good, very good. 2016-17, good, very good. Myself is very good. 17-18, good.
No, very good also.
No, good and very good. One portion. Now 18-19, very good. I am very good, always very good. So my merit is superior to him, Lordship.
That is your contention.
That is the Lordship ACR.
Yes.
Because ACR have to be considered.
Government. Who's for the government?
He's for the JD and we are for the.
So who conducted the selection?
JD.
Yes, tell us how you have conducted.
Based on the ACR grading is done by the DC, particular petitioner. And
We are asking you who conducted the selection?
the chairman of the GAD, of the committee.
Who is the chairman?
Chairman is the secretary to the government of Assam GAD,
Then,
along with the other members.
right.
And,
So how was it done?
that
After filing 2 affidavits, if you can't tell us, then when can you tell us? Your minds do not reflect how the merit has been, inter se merit has been decided.
if I may be allowed to bring the records, because I think the records will be required. On a similar case, another case, similar administrative officer case was there. There also, we had to bring the record. So I think, there it will come out.
We don't know. You have to tell us.
So, may give us.
It is not our job to dig up your records and find brownie points for you. You are the government. You tell us how this was conducted. After filing 2 affidavits, you are asking us whether you should bring the records, whether the evidence, the manner in how it is to be decided is found out.
Actually, I'll call for records.
What were you doing? Why the records are not here?
Lordship, on the last occasion, on the last occasion when this thing happened, he has not received this private respondent has not received the.
Mr. Counsel, don't keep shifting your responsibilities. You have filed once you file the affidavit, it is expected you will file it on the basis of the records.
We didn't produce it, Your Lordship, because of the fact that we didn't know his point of view. Also. I mean, Your Lordship, that's why
Did you file affidavit on behalf of your client?
we have filed it.
Did you file it only without verifying the records?
So we have verified, Your Lordship, but
Then?
we didn't. The required. The record
Is
will
it
be-
not elementary to find out how the merit was assessed?
I'll ensure my lord. Get the record.
No, getting the records for whom? You tell us, you search the records and tell us what is the process.
At
It's not
Lordship,
our
they can
job to
produce.
go through your dirty records.
Lordship, it will be difficult. Your Lordship. Because from Nalbari, Your Lordship, it will have. to-
Why
okay,
difficult?
GAP.
Why difficult? No, why is it difficult? You have filed, when did you file your affidavit? Your job is not to file the affidavit and consider the matter done and dusted. You have to support. The OM says that it has to be assessed on the basis of merit. How have you assessed the merit? Your affidavit does not reflect. There is a casual reference that merit, the ACRs have been considered. Where is that minutes, page number?
Page number 31.
31. See,
32
it says it examined the comparative statement. So if this is the comparative statement, then how have you assessed the merits?
If I may be allowed to get the records, can be fixed, Your Lordship, immediately. The ensuing vacation, Your Lordship, where
You get it on Tuesday. Tuesday. Get it on Tuesday. Get the records, show us how the merit was assessed. You should be grateful that we are not directing you to get the records by 4:30 today. We are giving you time till Tuesday. Get it, verify and tell us how you have done assess the merits, on what basis. Mr. S.K. Goswami, learned counsel for the petitioner, submits that the petitioner's case for consideration for promotion to the higher post of
Revenue Sirastadar.
Revenue Sirostadar was not considered in terms of the procedures laid down. Stop. As per the procedure laid down in the amended rules, which were amended in 1999, the board constituted for selection and promotion of the incumbents are required to examine individual cases, and only after taking into consideration the merit of the persons will prepare a list of names in order of preference for recruitment to the post. Stop. Mr. Goswami submits that this was flouted as from the minutes of the meeting of the promotion committee, which was held on 2nd of January 2020, which is available in the pleadings as Annexure 7, Roman 7, page 31. There is no reference as to how the inter se merit position was decided by the committee to consider the case of the private respondent number
Private respondent number 5. 4.
and overlooking the case of the petitioner. Stop. Mr. C.S. Hazarika appears for the,
number 2 and 3.
don't say 2 and 3, tell us the name of your clients.
Commissioner Lower, but now it will be Commissioner, it will not be there, but otherwise Commissioner Lower Assam Division and Deputy Commissioner.
Commissioner Lower Assam Division and Deputy Commissioner. Mr. A. Fukan appears for the GAD department, Government of Assam. Mr. R. Ali appears for the private respondent number 4. Stop. From the affidavits filed by the respective departments, it is seen that there is no clarity on the procedure adopted by the department while considering the cases of the private respondent number 4, overlooking the claim of the petitioner. Stop. While it is not denied that the procedure for selection and promotion is merit, inter se merit, comma, there are no averments in the affidavits filed as to how the inter se merit has been decided by the committee constituted for selection and promotion. Stop. Mr. A. Deka, A. Fukan, learned government advocate for the Standing Council for the GAD, submits that he be permitted to procure the records and place it before the court to support their stand that the department has duly considered the inter se merit between the petitioners and the private respondent. Stop. Considering the urgency expressed by the learned counsel for the petitioner, matter is again listed on Tuesday, which is 17, on which day the Mr. Fukan will produce the relevant records and satisfy the court as to how the procedure for deciding the inter se merit was undertaken by the committee constituted for promotion, placed on 17. Copy of this order be marked to the office of the marked to Mr. A. Fukan to enable him to obtain to carry out the directions of this court. Yes, who's for the CGSC? Newar.
Mr. Kaustubh Gogoi was there. my lord.
Lordship, he's coming, Your Lordship, maybe pass over timing, Your Lordship. He just informed me that it's on like so. I'll inform you, Your Lordship.
He wanted, my lord, as per instruction, he wanted some instruction, further instruction to get.
All right, time being. Time being.
May I please your lordship? I'm appearing on behalf of Mrs. R.S. Dury. She is unwell and she is admitted in the hospital. So matter may kindly be adjourned for a day, my lord.
None appears for the petitioner on call. MS. What is your name?
L. Wangsa.
L. Wangsa appears for the respondent
1, 2,
who
and 3.
submits that the standing council MS R.S. Dury is indisposed. Matter stands adjourned for 2 weeks.
Okay.
The departmental proceeding.
Hmm?
It's a departmental proceeding, lordship, and she was imposed penalty of censure and recovery of amount of rupees 1,15,900.
All right, we'll take it up for hearing then, admission hearing.
Yes.
Admission hearing.
Admission.
We'll have it on 16th November. 16th November for admission hearing. It is submitted by the parties that the councils that the pleadings are complete.
Lot.
Pleadings complete.
Yes, yes.
Matter be listed for admission hearing on 16/11.
Only thing other, they file a reply to the, if it is required, my lord, in the meantime,
Then we are not fixing a date. You have to take a call whether it is required or not.
Lordship, admittedly, lordship,
No, in that case, your lordship, fix
witnesses
it.
were not examined, lordship. And if they claim that.
We are
witnesses-
taking up for admission hearing on 16th.
Yes,
Keeping
yes,
it
all
like
right.
that. Yes.
Obliged.
Very good. What- Where is Mr. A. Chaliha Finance? Where is the Finance Council? None appears for the parties on poll. Yes, Mr. Chaliha? Some sanction proposal was.
Lordship, Lordship, here the case was the petitioners were asked for, they asked for the minimum of the pay scale, my lords. Here, we have received instructions that they have, the finance department has already sanctioned the amount. Now, Lordship, if the water resource authorities in the water resource department can just confirm whether or not they're getting the amount, Lordship, then the contempt will be closed. Because Lordship, the petitioners have not been appearing for the last 4 or 5 days. Lordship will peruse the last orders. So maybe it has been complied with, but finance department cannot confirm. Authorities in the water resource departments can confirm that, my lords.
Who's for the water resources?
Goswami, Lordship.
All right, list on list after 2 weeks.
Lordship.
It is submitted by Mr. E. Chaliha. None appears for the petitioner. List after 2 weeks. It is submitted by Mr. A. Chaliha, Learned Counsel, appearing for the finance department that the finance has already sanctioned
Yes, Lordship. We have already approved, Lordship, of that.
the amount, and now the amount is to be released by the
Benefits of the
concerned
minimum
department,
of the
namely
basic.
the water resources department. Stop. Since the council for the water resources is not available, matter stands adjourned for 2 weeks.
Lordship, in this contempt case, we have filed affidavit, Lordship. We have expressed our inability for non-compliance, Lordship, and we have preferred appeal, Lordship, which is in delay condonation stage, Lordship. Notice has been issued already, Lordship. IA Civil 1796 of 2023, Lordship.
Appeal against which order?
Appeal against,
9/11/2018, available at page 20. They filed the appeal after a lapse of 5 years. When the review petition was dismissed.
But registry has calculated it is 335 or something days, Lordship. We have filed review petition also, thereafter contempt.
However, there is no stay order from the London Division Bench, my lord, and this matter is
Yes,
pending since
this-
2019.
This is true, Lordship.
We are giving you 4 weeks further time.
Lordship.
You take whatever steps are necessary to,
Lordship, we have.
otherwise we'll
Lordship.
proceed with the hearing in the matter because your appeal is not admitted as yet.
Yet not dated, but
So there is no appeal pending as on date.
yes, but Lordship, no deliberate disobedience of this order because financial power is not with the BTC authority, Lordship.
It is with whom?
With finance department as government of Assam, Lordship. That is the problem, Lordship.
Then why have you filed an appeal?
Appeal for one memorandum of understanding was signed by BTC authority, government of Assam, and one another private agency, Lordship, for establishment of ITI Salakati, and Lordship, 28 numbers of posts were sanctioned by the government of Assam without finance. Lordship,
Hmm.
that we cannot bear the financial burden because finance is not a transfer subject to BTC Lordship. We have explained everything in our affidavit in opposition Lordship, and now we are trying to
Is the finance a party here?
Finance is a part.
in appeal we
No,
have met
BTC is a
party.
party. Contempt is a
In
BTC.
contempt not a party Lordship. We in appeal we have met party Lordship.
And this memorandum of understanding, my lord, of 2011, it is in view of this memorandum of understanding, the order was passed and the notification was published by the state of Assam. If I may take your lordship to page 15 of the contempt petition.
My humble submission is Lordship, there is no deliberate and willful violation of this order Lordship.
But I am directed to convey the sanction of the governor of Assam to the creation of 28 number of posts for ITS Salagati as given below under Labor and Employment Department BTC during 2016-17. Subject to the condition that the BTC authority shall bear all the recurring expenses such as payment of
Where
salary.
is the government order 2002, 2017, which was directed to be?
Page 15. My contempt petition. By this order 28 number of posts were created under Salagati under Labor and Employment Department. If I may read, my lord, I am
This is
directed
the
to.
sanction.
It is the sanction. With a
Section
cle-
of
with a-
post only
with a
Lordship.
clear understanding that subject to the condition that the BTC authority shall bear all the recurring expenses such as payment of salary and other administrative expenses for running the institute, and there will not be any financial implication on part of state government.
So therefore BTC is supposed to,
Yes.
Lordship, there was a clause Lordship in said memorandum of understanding Lordship. We can modify the memorandum of understanding. We sent fresh memorandum of understanding to the government of Assam Lordship, but they are not signing it and did not refuse it also Lordship. That's why we are filing this.
then you
appeal,
should have filed a review or whatever you should have
Review
done.
also
Review
filed
was
Lordship.
dismissed.
In this review, Lordship, as observation has been made that Lordship in page 22, Lordship. Page 22,
This is the writ petition, page 22.
page 22, no Lordship, review petition order. I have annexed it in my affidavit in opposition in contempt petition Lordship. Just a minute.
Page 33, my lord. In their
33
affidavit
of
in
affidavit
opposition.
in opposition Lordship. And relevant portion is at page
13, my lord, page 39.
39 Lordship. Paragraph 14. So paragraph 13 Lordship, with regards to the submission of Mr. Deori, this court is in view that until and unless the clarification issued by the state government owing financial liability in respect of creation of the post in ITI Salakati under MOU, the ongoing discussions stated to be taking place between the state government and the BTC cannot be considered to be a ground for review of the court's order. It is only when the state government assured the BTC authorities that it would take the financial liability in respect of creation of the aforementioned 28 post or necessary changes are made in clause 4 of the MOU in terms of clause 16. It cannot be construed that BTC authority are not liable for financial implications in respect of the creation of the aforementioned post. Accordingly, for the reasons discussed above, this review petition is closed with liberty granted to the review petitioner to approach the court again if necessary in the event of the review of the MOU or entering into a fresh MOU as per clause 16 of MOU resulting into changes of position with regards to the financial liability in respect of creation of aforementioned 28 numbers of post Lordship. Lordship, after filing.
So this is reiterating whatever was said
Yes,
earlier.
Lordship, but therefore we have filed appeal because we have
Right.
sent fresh
We'll
MOU.
give you
Lordship.
4 weeks, 4
Lordship,
weeks.
Lordship.
That will be
Deeply
listed
appreciate.
after 4 weeks as it is submitted by the Standing Council BTC that an appeal has been preferred against the judgment and order dated
9/11/2018.
9/11/2018 passed in WPC number
1812 of 18.
1812 of 2018. You submitted that the matter that the application for condonation of delay is still pending and has not been condoned as on date. Let the matter be listed after 4 weeks. We'll see what happens after that.
Deeply obliged.
Obliged.
Weeks.
Newly implemented respondent has appeared today, my lord.
Yes,
Lordship, we have been implemented, Lordship, and Lordship, I'll be needing some time, Lordship, to file my affidavit. No,
Mr. A. Fukan appears for
Respond number 2, Lordship.
the newly impleted respondent number 2 and praise liberty of the court to file his reply. Mr. S. Bora, learned counsel for the petitioner, does not object. Placed after 4 weeks.
That will fix the date.
After 4 weeks, let him file.
Problem.
Deeply obliged.
He was supposed to implement a new incumbent, Lordship. Last occasion also they took time without taking consent.
Office, sorry, none appears for the petitioner on call. It is seen that by earlier order dated 17/7/2023, it was submitted that the earlier engaged counsel had expired in the meantime, and the petitioner was granted time to make alternative arrangements. However, none has appeared on behalf of the respondents, but on behalf of the petitioner, Mr. Sharma, U. Sharma.
SR Bora.
Sorry, S.R. Boro appears for the petitioner. What do you have to say regarding compliance of this order?
Lordship, actually, he is not cooperating the authority, Lordship. We need some certain documents. He has expressed his inability to provide those documents, Lordship.
It is further submitted by Mr. Borua that the authorities have been requesting the petitioner to furnish relevant documents so that the directions of the court passed by order dated 27/2/2023 as in WPC 678 of 2019 can be complied with. However, the document sought for has not been furnished by the petitioner till date, because of which the order has not been carried out. Order is not, could not be carried out. Stop. Under such circumstances, matter stands adjourned for 4 weeks. Registry is directed to intimate the petitioner about the earlier order dated 17/7/2023 as well as the order dated an order passed today. Please after 4 weeks.
In this case, Lordship, I have been directed to obtain the instructions and also directed the petitioners to submit copy. But copy was not been served upon me, Lordship.
Lordship, I will serve within the day, during the course of the day.
And Lordship, a copy of this order may also be furnished to me, so as because it's a contempt case, Lordship, otherwise.
Mr.
S. Gautam, your Lordship.
S.
Gautam.
Gautam, learned counsel, appears for the petitioner. Mr. H. Sharma, additional senior government advocate, appears for the respondent, who submits that copy of the contempt petition has not been furnished, because of which necessary instructions could not be obtained by him. Mr. Sharma has entered appearance at the request of the court in terms of the earlier order passed dated 2/02/06/2023. Stop. Let the matter be listed after 4 weeks, enabling Mr. Sharma to obtain the required instructions with regard to the compliance of the directions contained in the order dated so and so, passed in WPC so and so. Copy of the orders dated 2/6/2023 and the order passed today, namely 13/10/2023, be served on the Mr. Sharma by the registry.
Much obliged.
Yes, what instructions have come?
Lordship. But I have received the records from the vigilance, my lord. And
No, what does it show? What does it reveal?
but in fact, my lord, I humbly humbly submit, my lord, that the office note, the seizure list, from the seizure list, my lord, it could be seen at page 33, my lord, lordship can see that there is a CD, my lord, they have seized. But that CD they could not, that CD contains the rejected candidate list, name of the rejected candidate appear in the written, all those things are there. They could not give us that. Otherwise, page 33, kindly see the description of seized exhibits. This is their seizure list from that times.
Why they could not give you?
But I'm just reading there. One compact disc soft copy stated to be containing list of admit cards, memo of rejected candidates and candidate appear in the written examination in respect of recruitment process held under the Director of Social Welfare Assam. But we have also sought for last page 93. We have sought for that. I talked to the SP Vigilance also. He said that the particular CD they directly cannot give. For that they have to send the material to the forensic. From forensic, it is a lengthy process or long process. They can give after that only. Otherwise also, my lord, whatever material is available with your lordship now, from that material, my lord, so far we have received, and we have also from our office, my lord, we have got some of the records. But kindly see the first page. This is the note sheet of the file. There, lordship may kindly come to.
We only want to know one thing, whether any posts in respect of persons with disability, whether any selection with regard to those people were made.
No.
If yes, the list and what is the condition of the petitioner, that's all.
In this selection process, no physically challenged persons were considered because my lord, no physically challenged persons were post earmarked for this 20. But here, my lord, what has happened? I'm just indicating, my lord. In 2013, there was an advertisement. A special drive was there for filling up 19 posts of physically challenged person, and that 2013 advertisement appointment were made in 2015.
This is which advertisement?
This is of 2014. This
14.
This is of 2014 in the month of February 24th of February, the advertisement was issued. And in this, no post has been earmarked for physically challenged. In the bunch, I have given the 2013 advertisement.
Where are what does the CD contain?
CD contains, kindly see page 33, one compact disc soft copy stated to be containing list of admit cards, name of rejected candidate and candidate appeared in the written examination in respect of the recruitment process held under the directorate. So all the persons who have appeared in the written test, and that is there, my lord. And there is a letter from the e-Gramin. I have e-Gramin service was engaged
by the directorate to conduct the entire selection process. Kindly come to page
No, But
46.
where is the select list?
Well, select list is there.
Where?
Select list, kindly see. The final select list at page 55 in the back, page 55.
Okay.
Sorry, my lord, page 57. This is the combined list, the supervisor regular. We are concerned with supervisor regular. my lord. Page 57.
Okay.
Supervisor regular, serial number 1, Bandita Soikia onwards, up to 20, my lord. 24.
So it is admitted that during this drive, there was no
No.
provision for selection of persons with disability.
Lordship. And kindly come to page 46, my lord.
Hmm.
Page 46. This is a letter, my lord, by the e-government whom we have engaged for conducting that process. They in reply said that we would like to inform you that as per advertisement published by your directorate by number so and so dated 24/2/2014, we have not received any separate application under the category of persons with disability as per existing government norms with separate disability certificate attached for the post of supervisor regular. This was there. And kindly see the read petition. For the special drive, I have indicated to your lordship, which was undertaken in the year 2013.
Yes. Page number?
Page number 43. Page
Yes.
43. Supervisor. Well, the applications in standard form of application prescribed in Assam Gazette are invited. Assam Gazette Part 9 are invited for filling up vacancies against the post mentioned below from the candidates of persons with disabilities who are citizen of India and fulfill the eligibility norms, educational qualification as etc. So this is only for the persons with disability. And kindly come to page 45. These are the 19% selected and appointed. The first seven.
Which
lordship,
page you are referring to?
Page 40, I have.
Of the records, of these records?
Of these records today I
Okay.
have given. Page 43.
40,
Page
Four.
43, my lord.
43.
Page 43.
Yes.
This is an advertisement issued in the year 2013, 23rd of May 2013. This situation vacant. Application in standard form of application prescribed in Assam Gazette Part 9 are invited for filling up vacancies against the post mentioned below from the candidates of persons with disabilities who are citizens of India. There are total 19 posts in this column. Total number of vacancies, lot people find 19. And kindly come to page 45. These are the list of selected candidates in
This
order
is,
of
no, this is for the subsequent or
no, this is
concern?
no, this is what I am indicating. A special drive was conducted in 2013.
Huh.
And the advertisement which is under challenge in this writ petition is of 2014.
Okay.
Well, a special drive in the year 2009, 2013, we have conducted to fill up 19 posts of supervisor. And page 45, this is the merit list. We have filled up 19 posts.
Hmm.
Well, orthopedically handicapped, lordship will find 7. Then 6 number of visually impaired. Then hearing impaired, lordship will find 6. Page 45. But I would like to indicate, Lord, this 13 vacancy we have filled up in 2015. And the 14 advertisement we have filled up in 16. In that 14 vacancy, Lord, there are no post has been kept, Lord.
For persons with disability.
Persons with disability. Lord, in the writ petition, I would like to just indicate one thing. Lord, the petitioner is claiming that the disability benefit. Kindly see page 17, NHA 1. Page 17, NHA 1. Yeah, the original is at page 18.
Yes.
This is the disability certificate given by the petitioner. The date of issue is 6/5/2005. It is valid up to 3 years. The advertisement is of 2014.
No valid certificate has been annexed even in the writ petition, my lord.
So this is besides the point.
And can you see the advertisement is at page 29.
Hmm.
After the advertisement, the petitioner at page 30 has filed a representation to the director.
But why did you reflect that caste certificate and copies of disability certificate, etc.
No,
necessary?
in the advertisement, it is
Why?
it is a mistake, my lord. It is a mistake. It is a regular format, my lord, they have published. Otherwise, my lord, for this 2014 selection process, the authority
Not only, you can't just say this is a mistake. Page number 29, if you look
Yes.
into the reservation
Correct.
below, for every post,
for everything, my lord, it's a format.
you
they
are
have
saying that reservation, including
For-
reservation of persons with
Yes.
disability.
Yes. For SC, STP, STH, OBC, MOBC category candidates, so and so, including reservation for persons with disabilities as per existing norms.
That's
These
right.
are one of, these are, I have talked to them a lot. They could only say a lot that as per the, this is, I cannot deny. And then they said that this is as per the, it's a normal course, of this has been edit. Well, they have also framed a guideline for conducting this particular selection of 2014. In the record, I have placed that guideline. So in that guideline, that there is nothing as regards the disability below. That guideline in the bunch I have placed, lot of people find at page 20.
Yes.
Page 20 is the guidelines. They have framed the guidelines for written examination for the persons of junior assistant, graduate teacher, arts, undergraduate teacher, statistical assistant, supervisor, field assistant, LDA cum typist, etc. under the director. These guidelines are to be read in conjunction with the advertisement published by number so and so dated 24/2/2014 and advertisement number so and so dated 24/2/2014 under the Directorate of Social Welfare Assam, Ujan Bazar, Guwahati 1. They have said, but here I did not find the serial number. They have not mentioned about the physical disability. I have not found that aspect. They have not mentioned anything anywhere in this guideline.
Not required to be mentioned. It's a mandate of a statute.
But now from the records, I could only submit a lot because no further record is available at this stage with us. What we can only submit that for those 20 posts, since there was no person with disability candidate, no other candidate appeared, and they have also not kept. And that apart, these guidelines also doesn't suggest that the persons with disability, because if one post has to be kept, then they have to frame a guideline that whether it will go to orthopedically handicapped or visually handicapped or hearing impaired, because the disability has 3 categories at that point. Nothing has been stated yet that this disability will go to that particular category. Only for that, I am indicating that guideline. So,
Yes.
the record now we have received from the vigilance, it indicates that the final merit list I have pointed out at page 70, page 57, and the combined merit list, and next year they have given page 75 of that. This list, logic will find the candidates at serial number 1. Ultimately, from this list, 20 persons have been appointed. Serial number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 14, 16, 19, 20.
23, 24, 27, 31, and 32. They are appointed in the final merit circular of 2024. At page 57. These 20 posts have been filled up. And unreserved, they have taken 10. SC2, STP2, STH1, and OBC 5. OBC MOBC 5. And
Yes.
one vital aspect further in the petition below. At page 6, at annexure 6, page 32, this is the admit card given to the petitioner.
Yes.
The caste of the petitioner has been mentioned as OBC. And in this admit card below, nowhere it is mentioned that physically disabled category or nothing else. And that about the application of the petitioner, that page 30 application for appointment of supervisor under ICPS. The undersigned respectfully states that the undersigned has submitted an application. After submission of the application, she said, for a post of supervisor of ICPS under the Social Welfare Department in pursuance of the advertisement dated 24/2/2014, file number so and so. With deep sorrow, I would like to mention that I am a physically handicapped and qualified and unemployed girl. So I hereby request you to appoint me as supervisor in a vacant post at ICPS. This is the application representation submitted to the director after submission of the application. And we have said in the affidavit that as per the information received from the authority who has conducted the selection process, the petitioner has secured 17 marks in written. Therefore, she was not called for the viva. And the written and the entire selection process consists of two parts, written and viva. And the candidates were.
So where do you say that? How much mark she has obtained?
Lot. Can you give me 1 minute?
Is the application form of the petitioner available on record somewhere?
That application, I have requested them. The applications were sent to the e-Grami. Now e-Grami has said that no, we have no record. Whatever we have returned, and everything has been seized. The application form is not available. I have asked them to try to get the application form.
Set up file. I would complete.
17 marks secured by the petitioner is an information given to us by the e-Gramin, my lord. But there is we don't have that because that particular city may have contained that.
Hmm.
This is an information given to us
Okay,
by e-Gramin.
all right.
And my lord, after I respectfully submit, my lord, after the 2014 advertisement, there was another special recruitment drive in 2018-19 for the physically challenged person. There, my lord, we have again appointed 21 supervisor regular. But
Please come again. This advertisement pertains to the year
14,
2014.
24 February 2014.
It was done in 2013.
14 in 2013 on 23rd May 2013, a special drive was for 19 posts. That was for only physically challenged person.
Where the petitioner did not reply.
No, as per my information, my lord, no record is there as regard application of the petitioner. Again, my lord, in 2018,
Hmm.
18-19, there is another special recruitment drive.
There,
There, 21 supervisor regular has been appointed.
no, in the subsequent advertisement also, petitioner did not apply.
As per my information,
So this will be in 2000.
18-19. 2018-19, it was in 18, appointments were made in 19, 21 posts.
That was for special drive.
It's a special drive. Special recruitment drive for, it was conducted by the state level police recruitment board. We engaged now instead of e-Gramin, we engaged state level police recruitment board.
Yes.
But, the petitioner has not annexed the valid certificate while filing the writ petition also. Writ petition. In fact, the certificate which is available in the writ petition, it is of 2005, valid for only for 3 years.
All right, that. You are questioning her disability also.
Validity of the certificate, no. I'm not on that.
So,
She may have.
what you're trying to say is that if it is valid for 3 years, that means if it is invalid, she'll not be considered to be person with disability.
No, Malad, my respectful submission is not that. Malad. My respectful submission is that.
That it was on papers, it was not valid.
No, she was. That is why she did not offer her candidacy. Malad. She did not offer her candidacy as a physically handicapped person.
Okay.
And that is why the representation was filed at page 30.
Certificate,
Certificate is of 6/5/2005.
where is it? Page number?
Page number 17 is the type copy. Original is at 18. Her date of birth is 86. She became 18 years. She attained the 18 years on 2004. At the age of 19 years, she obtained the certificate in 2005. And the advertisement of 2014. And page 30 of her application, can you see? This is an application. There is no, in my respectful submission, having a valid certificate and applied in a post under that particular category, this application is not at all called for. But further, Lordship may kindly see page 13 of the petition. What the petition has prayed in this case. Lord. May I read?
Just 1 minute.
Lord.
Where is that other representation you pointed out?
Page number 30 in the petition.
30.
30. Annexure 5. 31 is the original. 30 is the translated copy.
No, you said her ID was was valid only for 3 years.
It is annexure 1. Page 17.
That we have seen it, but then you said she did not apply, which is evident from some representation you said.
Page 30.
30.
30.
It doesn't indicate that she did not apply as a physically handicapped.
No, my respectful submission is, since she was not holding a valid certificate,
That is your submission.
that is my submission. That is my submission. That is why she could not, she did not file, and this representation was filed after submission of her application. It is stated by her, and even the admit card at page 632 is indicating only OBC. Well, she could have raised my respectful submission further. She could have raised a grievance that why you have shown me as OBC. You could have considered me as physically challenged, because I have offered that candidate. She appeared in the written case. Now says in the prayer, Lordship will find is prayed for setting aside the result of the written case.
Yes. Anything more?
But Lordship has directed us to produce the records, so that whatever relevant records we could we have produced, because the Lordship, as this is on the merit of the case, I have also submitted that. Well, if anything is
You let us hear the petitioner first.
Lordship.
Yes, Mr. Monto. They say that the advertisement reflecting PWD appears to be a mistake. There is a special drive earlier and a special drive later, where according to their information, no records show that you had applied. But in your admit card, you are shown as OBC without any reference to PWD.
That was their mentioning. Firstly, what now transpires is that admitted position is that pursuant to that 2014 advertisement in question, though or admitted position is that in that advertisement they specifically and categorically mention that there will be reservation for physically handicapped category.
Yes.
Record says, and they have admitted it was just mentioned. Secondly, they admit now that during that selection, nobody was selected under that category because there was no post. That is what the contention made now. Nobody was selected, no post. Referring to that Gramin, what they call it, Gramin E-Gramin, Lordship will kindly turn to 63.
That party you conducted the selection,
E-Gramin Services, page 63.
63. Yes.
Page 63. They say, it was their document. What does it reveal? They say that we requisition the services of this particular organization. They say, in reply to the above mentioned reference, we would like to inform you that as per advertisement published by your directorate, video number such and such dated 24/2/14, we had not received any separate application under the category of persons with disabilities as per existing government norms with this separate disability certificate attached for the post of supervisor regular. What does it say? It says that we have not received. Thus, it appears that no applications of disabled, physically handicapped category applicants were forwarded to them. They say, we have not received any application. That doesn't mean that nobody applied.
No, very well. If you want to, if you
Now,
insist on the detail, they say it is available in some CD.
Now, right. No, my contention, how they are trying to approve it and reprove it at the same time. They are contradicting themselves. If they contest my application, they could have very well said your application was rejected because your certificate is bad. Now,
Do you have a copy of that application you furnished?
which one?
The one you
Original
submitted?
application. Original application,
No, not original, copy of the original.
copy of the original, that has not been retained, that was submitted. That is acknowledged, yes. That was submitted. I submitted along with that my certificate in physically handicapped category.
Which certificate was not considered to be valid as per the
Now
document.
it has come up, whether they considered it that time.
No, but
Was
prima facie, if that is the certificate, then it was not valid on the day you submitted.
My lord, had it been the contention of the authorities that time, they could have very well rejected my, I could not have been invited for the test.
Because you are invited because you are shown to be an OBC
My
category
lord,
as
I
per the
belong to
admit,
OBC category, but at the same time, I am also PH.
which is not reflected in the
Well,
admit.
they have not reflected. They have not reflected this their fault, but I applied under physically handicapped. A person belonging to either ST, SC, OBC, anywhere, they may be physically handicapped. They belong to a physically handicapped category provided he or she is so declared. It is not that OBC mentioned means he or she cannot belong to physically handicapped category. It is very well there. My basic contention is that I applied under physically handicapped and they advertised that there is physically handicapped quota. Therefore, ultimately they say one thing, my lord, they said that nobody applied, no application was taken. Then my application, they again say that I secured 17 marks. I was there then in that case, in that category. They have not rejected my application.
No. The problem is that your application is not available either from your side or from their side. So to come to a conclusion or a finding that your category, you had applied for the PW, you had indeed applied for PWD and your candidature was considered under PWD. The court is not able to arrive at in the absence of any materials from either side.
Well,
Now, they say that the only relevant material available is in some form of a compact disc. Are you sure if there some material or?
Compact this indicates, that is why indicating that admit cards, reject candidate, name of rejected candidate appeared in the written exam. But we have not rejected the candidature of the petitioner. She has been considered as an OBC. She was given admit card. She appeared in the written.
It is that is her case,
Not-
that she applied for PWD.
No.
That
See,
is her case.
Well, my
On what
responsibility-
basis are you disputing her claims when you don't have any materials?
So she was not holding a certificate, valid certificate. And my lord, she has, after submission of the application, the application,
That-
she has given a representation.
Then,
Why?
no.
Representation
That
can.
is the presumption you are drawing
Yes.
My lord,
without any facts.
Lordship may kindly consider, Lordship may kindly consider that whether this is a reasonable presumption.
No, it's not a question of reasonable or unreasonable. It's a question based out on facts.
But even
It is
today-
your department who has to give us the facts. You are saying that the matter is under investigation, therefore these materials are not available. That is an issue that is for the department to figure out.
my lord, in fact, just one figure I got,
You'll have to tell us, you'll have to, if they're not available, you'll have to find out from the list of the candidates, who are the people, if at all, who are in, forget the select list.
the e-gram.
By now, if these people are working, then you must have opened their service books. So if there is any candidate with physically disability or anything like that, it will be reflected there.
Well, in the 113, list of 113, that is why I have given, Lord. List of 113, nobody is found physically challenged person.
Because
all are
contention is,
all are
let me
unreserved.
interfere here. Contention is that no post was reserved for that time for physically handicapped. Therefore, we didn't take anyone. That is why I say appropriating.
No, that is
Reprobate.
not my condition. That is not my condition.
If this is not the
That is
contention,
not my contention.
then what about those other candidates under this particular reserved category whose candidates have been rejected because they could not satisfy the norms? Let that produce. Let that document be produced. My lord. If I am out, I am out. But this contention, my lord, Lordship will kindly consider that time we did not appoint anybody. And therefore, we did not select anybody. So we did not appoint anybody under this reserve category because that time, no reservation. We have taken a special drive in 2013 that came to be concluded in 2015. Kindly see, my lord.
Yes.
15. And is it their case that time no post was vacant?
No, assuming one thing is certain, that they did not make reservations under the Act of 95 or 2016 as
14.
2000, at that point
At
of
that time it was 95.
95.
So,
Whether that is legal?
no, very well, assuming it is not, then whether it would be sufficient to interfere with the entire selection.
No, I am not asking for the.
That is your prayer in the petition.
Yes, but that I am modifying it after a long gap because my contention
What
is
is your
not
prayer?
against
What
others.
is your prayer today?
My prayer is that in this particular category, reserved category, if they can show that there were other people in the same category with me, and I have secured less mark than them, then I am out. But otherwise, I am entitled to be considered against the post because they could not have flouted the provision of law by saying that there is no post lying vacant because the record
They are
shows
unable to produce it. They are unable to produce it.
Lordship will then presume it in my favor. Because legally, they are bound to fill up a post on that day, at least one post out of 20. Because fact remains.
We would have presumed it in your face if you had given us two documents. Number one, a copy of the application indicating that you had applied under the PWD category besides any other category, number one. Number two, that your certificate showing you to be a person with disability was not invalid on the day you submitted your application. The document which you have enclosed was issued in, when was it issued? 2005.
Yes.
Valid for 3 years. 2008 it got expired. So the presumption,
My lord,
presumption which the counsel for the government is drawing is that
let
it
them
is
show that there was a law prevailing on that day that before, after 3 years, it will not be operating. And they cancel my candidacy on that.
No, this is your document, Mr.
No, that is what
Martho.
I'm saying. But they have
Your
taken the
document
point
says
now.
this is valid up to 3 years. So if you submit a document which is not valid,
Yes.
you can't demand the authorities to accept this document which is not
Let-
considered valid.
My lord, just a minute.
We are not questioning your condition as a person with disability.
You're right, I understand. 17. Persons with disability. ইয়াত ক'ত আছে এইটো যে 3 বছৰলৈ বেলেগ থাকিব আছে নেকি ভেলিড আপ টু 3 years yes yes my lord it is mentioned there valid for 3 years well my lordship will kindly appreciate if they could have selected me they could have said now whether this is valid or you are still suffering from that deficiency it should be tested they still do it that could have been done
You see, just as you are raising a presumption, they are raising a presumption that because it was invalid, you knew, therefore you did not apply under a person
No,
with
they
disability.
cannot say, this doesn't lie on their faith. They can say, or to my understanding, they can say, we have rejected because of this. Is it
Yeah.
their case? Let them say that.
No,
Then I'm,
they have not rejected you
exactly.
they
my
have
lord, that is
considered
their
you
life
as an-
problem.
as an OBC candidate.
Then let them show that OBC as an OBC, whether my candidature was considered under that category.
That they have shown in the records that marks you selected were not up to the level.
Now, my lord, what are the, they didn't call me for, that Viva. They didn't call me for Viva. So I presume that they didn't call me either because going by their stand taken before this honorable court at different times, different stand they have taken, that there was no post available under that category. Therefore, we didn't select anybody and you secured 17 marks.
These documents do not contain the name of the petitioner.
No, because no.
This is only the select list.
113 are the person who were called for the Viva, who cleared the written and called for the Viva, 113. Out of that, 13, 20 have been selected. That is why
Let them show that list, my lord, that for candidates who
Petitioner
were
claims
called
that
for
he
it.
was never called for Viva.
Yes,
it is an admitted thing. my lord.
Ah,
Because she scored less in the written, she was not called for Viva.
what is the score?
Well, the last candidate as per this list I have seen, kindly see at page 75 it starts. The written marks.
Why
kindly
can't you get the required marks which are obtained?
Well, that is in the CD. my lord.
So
That-
you call
that-
who's in charge of the CD?
Look,
Who's
that-
in charge of the CD?
well, the deputy from these copies are given certified copy has been given by the deputy superintendent of police vigilance and anti-corruption.
You call him to the court if you are unable to get it.
Well, they said that we have page 93. Can you see the letter we have written?
We have seen it. They say that it will come through forensic this and that, but we are in the midst of a hearing where you are unable to give us the required detail on the ground that it is under this CD or that CD matter is under investigation.
Seizure list I have-
When was the seizure made?
Seizure was made, the list I have given, seizure was made well, in 2016, 8/12/2016,
16.
page 34.
Till that, the investigations are still not complete.
Well,
That's another very good reason to call for the SP. Why not call for the SP?
possibly the trial is going on or something, because he said me, I have talked to our phone, he informed me that I have to take the permission from the court, because the.
Which
contact-
court?
The law court, the
Hmm.
trial court. I have to take the permission from the trial court and the compact disc, just we cannot copy because it is a seized document. It has to go to the forensic because the authenticity has to be
Whatever
there.
he has to do, we want to see what is there.
He
So
said-
if your explanation is not sufficient, we'll be required to call him to court.
Well, kindly appreciate, Lord. We have asked for them, the seizure list indicates that. And if he informed that.
See,
some
the whole
time is
issue,
required.
the whole issue boils down to two things. Whether she applied, if she applied, in what category? Whatever category she had applied, how did you consider her candidature? That's all. These are the three vital things which are not available in spite of all these voluminous documents being presented before the court.
Lord, admit card shows that she has been considered as a
Correct.
OBC candidate. She
Now,
appeared-
what is the marks obtained as an OBC candidate?
that Malad marks, in fact, because of the seizure, we are not in a position, but we have been informed that it is.
That is the crux of the matter. You
And-
get us the marks.
And Malad, the petitioner has not challenged that illegally I have not been called for the Viva.
This is the matter of 2000 what, 16?
16.
Then we are in 23, we are still struggling to understand what the facts are involved,
That is why, well, time and again, they come up with new pleas.
No, I
every
am,
time.
today, my lord,
which is
I-
why we wanted your presence.
No, today my respectful submission is not that these are the records available, otherwise this is the position as regards the.
These
the
records do
city,
not answer the query raised in the court. So if you say these records are available in the CD, you'll have to find ways and means of getting it, or we call for the SP.
my lord, 33, page 33, my lord, I'll definitely, I have, that is why my lord, considering the issue, I have called him telephonically. My lord. He informed me the procedure, I have indicated, my lord. Definitely, I'll try to get. I'm just indicating for the, my lord, at the cost of repetition, kindly allow me, my lord.
You have to just show us that whatever
is-
category you consider the petitioner, her consideration was done fairly and
Yes.
she did not succeed.
Two things are available apparent from the record. Number one is OBC, she has been considered as OBC. And number two, the e-Government has said that we have not received any application under physically disabled category.
Quite right,
Now-
but you did not reject her candidature. You considered her.
We have not received because she has applied as a OBC candidate, my lord. We have considered her. as a
Here I am
OBC candidate.
Therefore, what is the status of the consideration? What is the marks
Well,
attributed to her?
She could not, she get less mark in the written, that is why is a.
That is a presumption.
This is an information, my lord. We.
On the basis of a presumption.
Well,
Who has given that information?
The written examination.
No, who has
respect-
given that information?
From the IO, my lord, they have.
How will the IO know when it is there in the CD, which he cannot open it without the
No,
leave
no,
of the
CD
court?
CD he can open for the investigation purpose, but he cannot give us the copy. For giving copy permission is. required.
Let him bring the CD here, we'll examine, you examine it
No,
in court.
I asked him, my lord, I'll ask him, my lord. I
Huh?
can
You examine in
I can
court.
ask him, if he doesn't give us, he can come and directly show it to the court. my lord. I'll
He-
ask him that.
He can do that.
I'll ask him that.
You call him to court
I'll ask him.
Monday.
I'll ask him, my lord. Just, if that is possible for him. The criminal.
We rely on the council. If you see and tell us that this is what will record your submission.
No, my lord, I don't.
But
want
if
to
you
see-
think that it is not happening, we are required to go through the records ourselves. We'll go. We'll have to just call him. That's all. You tell us when you can get the information.
Well, I can get the information by, at 2, I'll inform you what can be done.
You
As-
inform.
What is the earliest point of time and in what manner that we can do?
We just need the information. How did the petitioner, what marks or how was her case considered? OBC, general, PWD, whatever considered. That's all. That's the only information we require. If you can get a printout of the record, very well. If you cannot, at least physically you can verify.
Well, I have repeatedly asked them. He was not considered. as-
And it might help if you get a copy of the charge sheet which was filed before the authority. What are the charges level?
In the charge sheet, possibly these details will not come.
May not be, but what is the charge and against whom?
It is the vigilance says because the selection process is under this. Ultimately, in the record I have given, the government has, first salary has been sanctioned by the government and the persons are getting salary because that is there. Look, the marks secured by the candidate, the petitioner is the main thing. Lord. I'll just ask him to get them. The marks secured by the petitioner in the written. That is the thing. Lord. Otherwise, she has been considered as OBC candidate. It is apparent from the.
Let that
and
list
it
be
is-
produced, my lord, category wise list, which category, how many candidates applied,
the
and my name appears in which category.
Petitioner is hurting, my lord. Lordship may kindly forgive him, my lord. Petitioner is hurting all these things despite his ineligibility. my lord.
No, ineligibility is in respect of PWD. But you did not reject her case.
Yes.
You should
No.
have rejected
Because PWD was not. filed.
because it is
Yes.
your presumption on the basis of which you are submitting that because there were no valid documents,
No. That is not my
she did
submission.
not apply.
No, that is not my submission. My respectful submission before your lordship is
Hmm.
petitioner did not made her application under that category because number one, possibly she has no certificate as on today.
That is what we said.
And secondly, that is why she has filed an application subsequently.
There's a presumption.
And my lord, the admit card shows as OBC.
In fact, there is no challenge to that. Why you have shown me as OBC? I have applied for this.
All right, this is her default, but you have issued an admit card.
Admit card is OBC.
So once the admit card is issued, you have to tell us pursuant to these whether she appeared or not,
She appeared.
whether the marks are there or not.
No, it is her case that she appeared.
She appeared, but
appeared.
your information is not there whether she appeared. If
Yes,
she
yes.
appeared, then she must have written something, written test or viva.
That is what I have said, that in written she appeared, but she was not called for the viva. Matlab, I'll get the marks, and the e-gramin also said page 63 is a part of record, that nobody has applied for a person under that particular.
Very well, under OBC.
OBC she applied.
So that is the marks we want.
Lordship, that marks I will get. That
Yeah.
marks I'll.
Tell us when you can
Yes,
get
yes,
it.
yes.
When you can get it.
Well, at 2, I'll inform the court how
All
much
right.
time he will take. Because without asking him, it is difficult for me to tell.
Very well.
Lordship will direct that they should come up with the records, to
Let him-
clarify these issues.
Let him inform
My lord,
the court.
at two, my lord, my friend will come up,
Yes,
then Lordship will record this thing.
we'll do that.
My friend will be here.
All we'll do. that.
Because to cleanse the issue, whole issue, question now as was fallen from your lordship, it boils down to, they say probably I have not applied in that category,
Right,
but
we'll-
I am saying that I applied
We'll
in that
record it.
category.
We'll record it.
Yes, that presumption will not do. Let them show in which category they considered by case.
These
They
are,
must appear, and then how much mark I secured, how many people have been appointed in the claim I have raised in the PHC. They said nobody was appointed.
We'll record it.
Then rest things will come.
We'll
well,
record it.
in fact, how many persons have been appeared, considered, these are all available with your lordship. Those records are there. This is for your, lordship can consider that.
Yeah, at 2 o'clock.
It is available. I'll inform how much time they will take, to inform the honorable court about the marks secured by the person. That I will.
Well, that there was an inquiry and the whole issue is pending. That itself speaks a volume about how the things went on that time.
Then petitioner cannot claim. If petitioner says that everything is illegal, how petitioner can claim appointment out of that
Fine,
illegal
my lord.
process?
Fine, you answered that.
Just making, my lord,
If I am
No,
not
these
eligible,
are besides the point. Now, you
Correct,
get the information, tell us.
yes,
That's-
if I am not
Yes,
eligible,
Yes.
court will say no.
Yes.
But otherwise, why you don't produce the relevant material report?
my lord, to the extent possible, we will definitely.
Yes, all right.
All right.
Yes.
Lordship, on the last occasion, my lord had desired to peruse my lord that one notification, my lord, of the finance department, that is 16/9/2021. It is there, I have placed it on record. Lordship may kindly peruse it, my lord. Although it is dated, my lord, Lordship may kindly come to, my lord, the third page. There, my lord.
9-10.
No, it is, although it is dated 9/10, down below lordship will see, it is signed on 16/9.
All right.
So it is that notification, my lord. Otherwise, the number also tallies. I have inquired with the department, my lord.
Okay.
It is 16/9. Now, by dint of this communication, my lord,
Hmm.
the benefit, my lord, arising out of the decision in Upendas
Hmm.
has been extended, my lord, to both the categories of persons who were appointed, my lord, prior to coming into effect of AFRBM Act and who were appointed post, my lord, AFRBM Act. So here, my lord, admittedly, the petitioner's case is that, my lord,
They were-
they were appointed post FRBM Act,
Ah.
and the date is, my
So
lord,
their
that
cases are to be considered now.
their cases are to be considered.
Yes, so will you
Lordship-
consider their cases?
Yes, my lord.
Huh?
Lordship will dispose of the cases, my lord, directing both, my lord, the parent department as well as, my lord, the finance department to consider the case, my lord, within a time frame.
All right, heard, learned counsel. For the parties. This writ petition is filed by the petitioners who were appointed as casual employees within bracket peon cum chowkidar on 15/12/2005 and 31/12/2005 respectively in the Gaon Panchayat office under Hailakandi Zila Porikot. Stop. The claim of the petitioners are that they have been continuously discharging their services for more than 14 years without break. Stop. Learned counsel for the petitioner submits that this court, while considering a similar issue which arose in Writ Appeal 45 of 2014 by order dated 8/6/2017, directed the authorities to pay the minimum of pay scale to all master role workers / casual workers working since last more than 10 years.
Not in center.
Following the decision of the apex court rendered in State of Punjab versus Jagjit Singh,
My lord,
reported in 2017, volume 1, SCC 148.
my lord.
Stop. Learned counsel for the petitioner submits that although the Panchayat and Rural Development Department prepared a consolidated list of 3664 casual workers, including the names of the petitioners. However, their claims were not considered by referring to a notification dated 8/3. Where is 8/3?
66.
8/3
2019, my lord.
2019. Page number
66.
66. Issued by the Finance Department, wherein it was provided that only master role workers who were appointed prior to the FRBM period, i.e. 1st of September 2005, will be considered for grant of minimum scale of pay as directed by this court by the judgment and order dated 8/6/2017, passed in Writ Appeal 45 of 2014. Stop. Para. On earlier dates, the learned counsel for the finance was permitted to obtain the required instructions. Today, when the matter is called up, Mr. Porpuzari has placed before the court notification number FEC within bracket Roman 2 80/2018/156, which was issued on 16/9/2021, which was issued on so and so date under the signatures of the Commissioner and Secretary to the Government of Assam Finance Department. Stop. A perusal of the said notification reveals that the government has recalled its earlier decision of grant of minimum of pay scale only to master role workers / work charged personnels, work charged workers who were appointed prior to AFRBM period. Stop. By the said notification, a decision was taken that all master role workers and / work charge workers appointed both prior and post AFRBM period will be granted the minimum of pay scale in terms of the orders dated 8/6/2017, passed in writ appeal 45 of 2014 within brackets State of Assam versus Upen Das and others. Stop. Para, in view of such submissions made by the council for the respondent, and in view of the notification number so and so dated 16/9/2012
21.
issued under the signatures of Commissioner and Secretary Government of Assam, Finance Department. This court is of the view that the writ petition can be closed with direction to the respondent authorities,
Finance department.
namely
Panchayat has already forwarded your lordship.
who,
The Panchayat has already forwarded, madam. Let it
namely
be.
to the Finance Department. Respondent number 2 to consider the proposal for grant of minimum scale of pay in terms of order dated so and so, passed in writ appeal 45 of so and so, in respect of the writ petitioner, as stated by the Standing Council for the Panchayat and Rural Development Department. Stop. The Finance Department will thereafter pass appropriate orders in terms of the directions contained in writ appeal, order dated so and so, passed in writ appeal 45 within a period of 30 days. 30 days,
My lord, let it be, my lord, 2 months, my lord, here.
60 days,
60 days.
within a period of 60 days from the date of receipt of a certified copy of this order along with an application filed by the petitioner. Stop. In terms of the above directions, the writ petition stands closed and disposed. Interim orders, if any, stands merged.
Lordship may kindly direct both the finance as well as PNRD. My lord, we need to verify both the departments. Because whether,
The PNRD department will also ensure that any particulars, details, etc., that may be necessary in respect of the writ petitioners to comply with the directions of this court, the same shall be forthwith furnished to the Finance Department.
absolutely, absolutely.
Disposed. Yes.
I'm so obliged.
Obliged.
What?
My lord, item number 30, Mr. Constable Gogoi wants time, my lord, till Monday, he has to get some further instruction, my lord.
All right, item 30 at the request of Mr. K. Gogoi. On behalf, request made on behalf of Mr. K. Gogoi, matter stands. Be listed after vacations.
No, my lord, Monday he wants,
Monday,
he will get the instruction 2 days.
all right, Monday.
And my lord,
Monday
government
would be
lawyer,
16.
he get the
16th or 17th?
16 or 17.
16th or 17th? Give us a date specifically. 16th, 17th,
17.
Tuesday.
Yeah.
Mr. A. Chakraborty appears for the government. Yes.
May I please also? May I present my light, order dated 19/6/20 may be kindly be looked into, my lord.
Yes, Mr. Sharma,
Yes, Your Lordship.
any further
Yes, Your Lordship.
submissions?
Sir,
There
as I
are
was-
judgments of this court as well as the apex court that after 7 years presumption.
Yes, but then the issue was, how was that presumption to be taken? Because section 108 of the Evidence Act says it has to be proved.
Now, that is where the other question comes in. If section 108 is considered to be a presumption,
Yes.
then no proof is necessary. If it is to be proved, then there is no presumption.
Yes.
Mandate of the statute is that it is 108, which is a presumption after 7 years.
May I trouble you also with section 108 again, just for a moment?
We have read and reread.
Yes.
Yes,
Section 108.
and it is proved. That is what you want to
Provided that
highlight.
when the question is whether a man is alive or dead, and it is proved, yes, exactly. And it is proved that he has not been heard of by those who have necessarily heard of to be alive, the burden of proving that shifts to the person who affirms it. So I was placing that from the viewpoint that first the person who is trying to take a benefit, because this is a benefit that he is claiming, benefit of a property that he is claiming, then he has to prove that the person is no longer available, no longer seen for last 7 years, and therefore the presumption can be brought in. Now, in that regard, I came across one judgment just for persuasive nature lordship of the Calcutta High Court, wherein it says that yes, the declaration is not. Let us read that line. Therefore, no suit lies for a declaration that a person not having been heard for 7 years was deemed to be dead, unless the suitor seeks to establish that he is entitled to any legal character or to any right as to any property. So unless it says, if a declaration is to be given in general, it doesn't require any suit, unless, I'm just placing that for a lot. Yes. Therefore, paragraph 9.
Yes.
It deals with section 108.
Yes.
I'm just reading that particular relevant portion. It is
Yes, please. Unless.
Yes. Therefore, no suit lies for a declaration that a person not having been heard for 7 years was deemed to be dead, unless the suitor seeks to establish that he is entitled to any legal character or to any right as to any property, inasmuch as a suit for declaration can be maintained only within the scope and ambit of section 34 of the Specific Relief Act.
If you go a few lines above, you will find
Yes.
what this court has just told you.
Yes.
Thus, the presumption is a rule of evidence.
Yes, exactly. So this is what it says.
By fiction, death is presumed. So
Yes.
therefore, there is a presumption. 7 years we have not heard.
Hmm.
Death.
But it is qualified by the
Unless
fact-
you say, no, he's alive, then you prove it by means of any document or anything that no, these are the circumstances under which we cannot say that he is dead.
I'm in agreement with your lordship on that aspect. But what it says is, for a general presumption regarding his death,
So this is not
presumption can
this
be-
is not a general presumption. They are
No.
claiming property.
that's what. Then therefore the unless comes into picture.
Huh,
Therefore, I am saying, lordship,
huh.
had it been a general presumption, is the person dead or alive? 7 years has elapsed, he is dead. But when a person, therefore, on that basis comes for a claim for a property, then the issue changes. Then the issue becomes something else. Therefore, the unless is very important.
No. See,
My understanding.
there is a judgment referred in the earlier judgment placed by Mr. Maheshwari.
Yes.
It was a judgment of the apex.
My lord, so far, my lord, 2010 CGLD 203.
There were two Supreme Court judgments in the judgment of Rajia Khatun, I think,
My
or the subsequent judgment. One is LICI,
LIC is defined.
LIC Anuradha, yes.
and there is another judgment,
My lord.
probably 85 or something supplementary. You see,
Jay Lakshmi Ammal.
in that matter, what happened was, on the facts of the case, the person against whom presumption was drawn was the husband of the plaintiff. So the person died. So there was a presumption, and he was the owner of some land. But this land was originally purchased by that person who disappeared along with his brother. So both the brother was also the owner, as also the person who died or is presumed to be dead. Now, after 7 years, his wife entered into an agreement giving away the property or selling away or something like that. Then the court said, you can't do that. Because before you claim your property, there has to be a partition.
Correct.
There has to be a partition. Now, here is a case, what you are trying to raise, if this is a case of, say, more than one wife, both are claiming pension or something like that, or maybe there is a dispute. Here, from the point of view of oil, there is no dispute. He was an employee, he is entitled to the pay benefits. He is not heard of, that is what his wife shares.
Regarding the entitlement, there is no dispute. The amount.
But what
Regarding the person
what
who
you are
will get the
proposing,
benefit.
what you are proposing, two coordinate benches of this court has already held. The doubt which you express is the doubt which was there in the mind of the court.
Yes, sir.
But if you look at it from the point of view of presumption, then a presumption can be drawn by this court. Unless you object, then
My
it cannot be
objection
granted.
is on record otherwise. My
Huh?
paragraph 29 of my affidavit, my objection regarding that debt is on record. My affidavit, paragraph 29, are categorically stated
But
that.
then you have to prove it. Why? Why you are objecting to the presumption?
Therefore, it may be, it will be in a declaratory suit. If he files a suit. Because I have not been able to, what I am trying to present lordship is this Calcutta judgment.
See, declaratory suit, forget the formalities. Even in a declaratory suit, how will it be proved that this man is dead? Because LIC and the Ambal judgment categorically holds that the presumption is with regard to death after 7 years, one day after 7 years. But no presumption with regard to how he died, under what circumstances, on
Or the
which day.
time of death. Yes, I understand.
So if you want a declaration to that effect, then you file a suit. Here there is no declaration.
I'll just place one similar municipal court order where these kind of declaratory suits have been filed. And
That's why, my lord, I'm submitting before lordship. that
just like
Order date 19/6/2019, passed by the Supreme Court may be seen in this case. What is contention, my lord?
that
He's
paragraph,
repeatedly-
paragraph 3, one of the issues. C, paragraph 3C. Otherwise, these kind of suits are filed for seeking declaration regarding debt. Under section 34 of Specific Relief Act, seeking a declaration because they are claiming a property. They're claiming there is a claim for a property of the person whose presumption of death has to be now taken by this court or by the lower court.
No, the only question is section 108, if you look into it. See, if it is proved that he has not been hurt,
That proving I'm on that lawsuit, that proof has it to be proved by some documents that can be brought by him to the authorities
we
or
don't know,
to a,
but if it is to be proved, that proof will only be with regard to that period of 7 years, within that period of 7 years, that person has not been hurt. That is the only proof.
yes.
Because if you can bring any proof to say that he died on so-and-so date under such and such circumstances, or he was traveling in a
I
public
understand.
vehicle, it met with an accident, everyone died, so presumption of death on such and such date, then it's a suit for declaration. But if it is to be proved that after 7 years, yes, he's declared to be dead, where is the presumption? Why have a presumption at all? Because you have proved it. Besides, of course, trying to understand how the plaintiff is going to prove it. On what basis will you prove? There is no documents. There are no photographs,
Only presumption.
only statements
Only the presumption. will
that we have
come.
not heard from him, which may not be contested by other persons.
Yes.
So, in the facts of the present case, are there any dispute from the point of view of oil that no, we have received a letter from him saying he is alive somewhere, or he has
My-
requested that the pensionary benefit should not be released in favor of his wife. There's nothing like that. No
Nothing of that
dispute.
sort. My only thing, paragraph, my averment says, since he's not been heard of, the wife should have brought some death certificate or some declaration from some competent court. That is my averment. I leave it to your lordship, but only that to that aspect, only that issue was there.
On the first day, I raised some queries, but fact remains that there are 2-3 judgments of this court.
Judgments are there.
Unless you distinguish it, it doesn't go before the High Court. You'll have to distinguish it, saying that this is not the correct proposition of law. Even I am finding it, I am agreeable with Mr. Sarma's contention that it has to be proved.
They are not only for 5 judgments are there.
That's okay. Number is not enough.
No,
It's not
I'm
relevant.
saying before.
Even one judgment is enough.
See, a person, whether he is alive or dead,
Right.
there are authorities in the state to do
Right.
it. Now, ordinarily, you should have applied for a death certificate.
Right.
In case if you have done it, they would have said you get an order of the court.
Then matter would be different. But I'm
Now
not-
you are maybe because they have come to an astute counsel like you said, don't apply, we'll go to the High
No,
Court.
no, no, I have not changed my law. I have not so mentioned in the court matter. Why I'll change my law? Because I'll.
Oh. You see, we are conscious of the fact that this is a pensionary benefit, but
No, this matter is pending. She is not
no,
without
pending
anything.
is okay. But you see, the only anxiety is whatever
Right.
we say becomes a precedent.
Right.
Therefore, it must be an attempt to lay down a correct precedent.
Right.
And if I cannot agree with the propositions earlier, I have to disagree. See, the only issue here is whether it is required to be proved, or is it good enough to take a presumption?
Well, I have filed the my lord FIR matter, and final report has been my lord report.
Final report
status-
only says he is not available,
Right.
not traced out. Have you gone through the judgments of this court?
I have given the my lord to head note of
Not
the
in
court.
details, otherwise.
Go
Not in
go through it.
Yes, sir.
Well, I have already.
Will not trouble you, but we'd like to take it up again next week, coming week. We want to be satisfied that yes, this is the
No, no,
order.
I have already handed over on the first day. my
No,
lord.
no, he will go through it and will apprise the court. We'll only trouble him, not you. Tuesday?
Next week.
No, you have to be there. Otherwise, we are passing an order today. Tuesday.
This is on the reopening date, Lord.
This is a pension matter.
And
My lord, I am hanging within.
on the reopening date, Lord.
Or you release the interim pension.
That time, pension is not there, my lord. Only amount is they are going to pay, my lord.
How much
Whatever
amount?
Admitted amount. my lord. They have, as per their affidavit, they have admitted certain amount, my lord. That is to be
It's
paid.
in the affidavit, Lord. So their amounts are there.
They have mentioned the amount, my lord. Page 84, my lord.
Is 89.
Relevant is 18. That amount is to be paid. Nothing more. I am not claiming anything, my lord. Whatever they have admitted, that is to be paid.
As it is pension amount, they will get from the next month only. If at all.
This amount.
If your lordship will have it on the day of reopening, on that day lordship can dispose of it.
Where have you stated?
Page 89. There's an additional affidavit filed on 22/9/2023. Running page 89, lordship. The amounts are given. Okay.
Whatever amount they have admitted, they may be paid.
Yes.
The tabular chart procedure, lordship.
First table of charges, my lord, page 88.
These are the amounts, 88, and pension is at page 89.
All right, we are keeping it for Tuesday. Your colleague, Mr. Kolita will be there. Let him handle. Mr. Maheshwari?
Yeah.
We'll just go through once again on Tuesday.
Ma'am,
Hey, we'll take up the order matters. If anyone is ready to take up.
much obliged.
Oblige, Your Lordship.
Yes. Forty-two has been adjourned, I think. Is it adjourned?
If I don't, I was not in.
42 adjourned one. Some affidavit was filed.
I had filed an affidavit, they may be
Ah,
trying to file on it.
no, affidavit probably has not been brought on record. Is it brought on record? When did you file it?
Lordship, on the last occasion, Lordship had it. Some miscommunication was there. My affidavit was there, his affidavit was not there.
All right, let us then take it up at 2 o'clock because the councils are not here. They may be.
It's been promoted earlier. My lord, the petitioner has been promoted, my lord, from grade 4 to grade 3, my lord. And thereafter, my lord, he, my lord, along with some other petitioners, has been reverted back to their my lord, grade 4 post without service, my lord, without serving them any notice. My lord, thereafter, he has approached before his honorable court, and my lord, the interim my lord, order of demotion has been stayed by the honorable. Thereafter, my lord,
Stayed or interfered? Which order? Which order? Which order?
my lord, that is on page, I mean, the contempt petition, my lord, that is that order.
Page number.
Page number, my lord. The my lord, relevant portion is at page 9.
35, 2019 order.
Right.
Yes, so it has been set aside.
Set aside.
Yes.
Thereafter, my lord, thereafter, my lord, we have also filed a my lord, review petition.
Review petition.
Review petition.
Why?
My lord, review petition only to my lord because some similarly situated my lord candidate has filed a review petition. My lord, that my lord seeking some specification that my lord getting aside of this order, meaning thereby they may be allowed to hold the post, my lord. They were holding prior, my lord, demotion or to reverted back to their earlier post.
Goes without saying, that is with it order, the order of demoting you has been set aside.
Set aside.
So what happened, Mr. Bhagavati?
What happened, Lordship? Actually, grade 4 employees, Lordship, lot of them, Lordship, were promoted to grade 3 post, Lordship, without following the process of law, Lordship. So when that matter was taken up by the authorities and we were reverted back, Lordship, different petitions were filed, Lordship. And in different petitions, orders were passed, Lordship, that
Now what happened? This order remains.
What happened, Lordship? After the order was passed, Lordship, lot of orders were there, Lordship. So the authorities took up all the cases together, Lordship. And they, according to, they had prepared a graduation list. And according to the graduation list, Lordship, they held a selection process and 9 persons were selected to be promoted to the post of grade 3. From
No,
grade 4.
no. In terms of para 4 direction,
Lordship,
page 9,
Lordship,
they were holding some higher post.
Lordship,
They were demoted
Lordship,
without issuing show cause
Lordship,
by an order dated 26/10/2016.
Lordship,
That was set aside.
Lordship,
So the moment it gets set aside,
Lordship,
the slate is clean.
Lordship. What happened,
So
Lordship?
they are still in the higher post.
Lordship, what happened, Lordship? There were a number of cases. They were to be taken up together, Lordship, and in different orders, Lordship, different orders were passed, Lordship. I have filed an affidavit, Lordship. Lordship may see in the affidavit, Lordship.
So we are only concerned with the compliance of this order.
Yes,
And
my
it
lord.
So far as the petitioner is
And
concerned.
what it was given, Lordship, liberty was given to the authorities to proceed accordance with law, Lordship. That the line carried that way.
No,
Lordship. That is what-
accordance with law with regard to demotion.
Lordship,
But the moment the order of demotion is set aside,
Lordship.
they are to be in the higher post only.
Lordship, that was there, but there were other cases also, Lordship, in wherein, Lordship, some different kinds of order were, if one is to be given that preference.
Then you
Lordship,
go and file an appeal or a review. That was not done.
He's referring some, my lord, the petition order, passing some, my lord, separate.
This
issue.
order
Lordship.
remains unless it is reviewed or appealed.
Lordship.
There is no hurdle on the part of the government to go and
Lordship, that was there, Lordship.
then
That government could
then
have,
if it has not been complied, we'll have to drop proceeding.
Lordship, that
Who-
was there, Lordship.
Then
But they thought that since the law, there was a given, there was
they
a
are
line, however,
thinking we are not responsible. How
liberty
they
is
think.
granted to the authorities to proceed in accordance with law. So they took up all the matters, Lordship.
But the petitioner is not one of those candidates.
He was one of the candidates. His case was also taken up for consideration.
Then what happened?
His serial number is Lordship 600 something, Lordship. So if he is to be, his serial number is 665, Lordship, 665. Only 8 persons were eligible for promotion, Lordship, 9 persons,
See, in terms of this order,
Lordship,
this order is a very simple order,
Lordship,
straight and simple, 4 paragraphs.
Lordship.
He was promoted by order dated 26/10/2016.
Lordship.
He could not have been demoted by issuing the impugned order. Impugned order is 5/1/2017. The promotion was cancelled.
Lordship.
It is not a case of promotion order being issued and he had not joined. He had already worked.
That is also true.
But then the order was cancelled and he was demoted. That order of cancellation was set
They
aside.
ought to have given a notice to him. They had,
Whatever.
Lordship, whatever.
It
Lordship,
was
yes, Lordship.
interfered with.
Understood, Lordship.
Now the effect of this order is that he'll continue to be in that post. Where is the scope of again selecting him and promoting him? Vacancies not being available. He's there. His order has to be reviewed or
Lordship, similar cases, lot of similar cases, Lordship, same ground. Lordship.
Mr. Bhagavati,
Understand,
can a
Lordship.
coordinate bench order be altered by another coordinate bench? Unless you
understand,
say,
Lordship. I
unless you
understand.
say that this
Lordship.
order cannot be complied with
Lordship,
because of orders being passed in other similar matters by a larger bench. Was it passed by division bench?
no, Lordship.
Then you cannot pick and choose that I like this order, so I'll proceed according to this order.
Lordship.
So far as the petitioner is concerned, this is the order that is applicable. So, therefore, it's contempt.
My lord,
Lordship. In the meantime, Lordship, he has also retired from service, Lord.
my lord, maybe, my lord, but not only he may
Maybe,
be
but then
promoted.
you are guilty of contempt.
Lord, he may be not only promoted. It is not my fault. My lord, may I just draw your lordship?
When did you retire?
My lord, in 2022.
Huh?
30 November 2022.
2020.
22.
2020. Thereafter, my lord, prior to this, my lord, that I have communicated.
And the
obviously, not
review
only-
order was
not
also,
only-
Lordship, brought to the notice on 29, that day before he retired.
We are giving you one opportunity that you release his financial dues notionally
Ma'am.
with effect from the date of this order,
Lordship.
or we are proceeding in contempt with you.
My-
If he has retired,
Lordship.
that means from the date he was promoted, when was he promoted? On 26/10/2016.
My lord.
So from 16 till his date of superannuation, he is deemed to be considered.
Yes, my lord, not
Understood,
only
Lord.
You get the instructions and we'll close the matter Monday,
Lordship.
Tuesday.
Tuesday will be too early, Lordship,
No,
because
no, this is 2019 matter.
Doesn't matter, my lord. There, my lord, we are, my lord, approaching regularly.
There is no other option but
I
to drop
understood, Lordship.
contempt.
In fact,
My
Lordship,
lord,
in a similar line, I have also told them, Lordship. But they said, we have already done this. What,
No, no,
how
no.
can we go back?
just for a
When,
moment.
when I got the matter, Lordship,
No, where's the
when I
question
got
of
the
going back?
matter,
My lord, just for a moment, may I?
when I got
my
the
lord, draw
contempt
your
matter, I
lordship-
explained it to them,
lordship
that
kind
this is the
attention.
condition.
My lord, I have filed an affidavit just for a moment, my lord. In my lord, that the similarly situated candidate, my lord, in the my lord, they have also filed a review petition, my lord. Similarly situated with the petitioners, they have communicated the review order. Thereafter, my lord, all these, my lord, the review petitioner has been promoted. He's saying that no, there is no vacancy, there is only 9 vacancy. My lord, I am annexing the my lord, that review order and the order of promotion. My lord, all the similarly situated has, my lord, has been-
Mr. Bhagavati, you take your
Speak.
instructions, or this appears to be out and out contempt.
Lordship,
We cannot allow officers to behave like this.
Lordship.
We are putting it up on Tuesday. You get your instructions or we proceed in contempt against the officers, all of them. If if they're retired, they'll be brought out of, that will not spare them.
Lordship. In fact, they are not here, Lordship, but they have they are not in holding the office. Lordship.
Whoever is holding the office, you get your instructions and we take it up on Tuesday. Mr. Bhagavati will obtain instructions as regards the compliance of the order dated 3005-2019, passed in WPC number 8127 of 2017.
Lordship, let it be Wednesday, but tomorrow will be a holiday, Lordship, second Saturday, Lordship.
All right, Wednesday. Matter be listed again on Wednesday. That is 18. Please get your instructions, otherwise this appears to be contempt.
Lordship.
Prime appears.
Understood, Lordship, but if I
We are
try
giving
to-
you an opportunity. If they don't follow, they will face consequences, whatever is there. Whatever is there.
I also tried to make them.
You tell
understand,
them.
Lordship.
We are not putting it in the order. If they do not rely on your good counsel, will face consequences. On 18th. Yes. Yes, Mr. Nath.
I spoke to the SP. He has instructed to pray for notify take up it on Wednesday at 2. They will try their.
Wednesday at 2.
They said that at least 3-4 days time is required. I said Wednesday, Thursday is the last day.
Wednesday at 2.
Lodge.
Matter be listed on Wednesday at 2 p.m. On which date Mr. Nath will endeavor to obtain the information or obtain the instructions stated to be available in a CD in the custody of special, what is that? Superintendent of Police, Crime Branch, CM Vigilance,
Vigilance and anti-corruption.
Vigilance and Anti-Corruption, Government of Assam.
As regard the marks obtained by him are in the detail.
In the CD may contain the marks obtained by various candidates, including the petitioner. Stop. The information be placed before the court on the next date fixed, which is 18/10/2023 at 2 p.m. Copy of this order be marked to the office of the Senior Government Advocate, Mr. D. Nath, enabling him to communicate the order of the court to the concerned respondents. Mr. N. M. Hazarika appears for the petitioner, led by Mr. K. K. Monto. Yes. Yes.
As per the last order to comply with. Lordship, the order has been complied with, and the last month's salary, we have a communication where 1 month's arrear salary was remained to be paid. That has been paid in September. Lordship.
All right, you have received.
Yes.
Order has been complied with.
Yeah.
All right, it is submitted by Mr. What is your name?
Yes, sir.
J. Soikia, Learned Counsel, appearing for the petitioner. That which order? I order.
I order, Lordship, it's
Order passed in, order dated 1/4/2019, passed in IA Civil 3140 of 2017, has been complied with. Mr. A. Cholia appears for the petitioner, who submits that
respondent.
the appears for the respondent number 1. 1 and 2, submits that the arrear salary which was left to be paid has also been released on
Lordship, in the month of September.
in the month of September 2023. The contempt, the order having been complied with, the court taking into consideration the submissions made by the respective councils, the court does not wish to proceed with the contempt petition any further. Accordingly, contempt case stands closed. Notice is issued a report. Disposed. Yes.
I have between instruction contempt or indictment.
Oh. Then any right to sue survives?
Yes, sir.
You want to file
Definitely, my lord.
application for substitution? Mr.
DK Das.
DK Das, Learned Counsel, for the petitioner submits that during the pendency of the case, the contemner
Contempt.
or the contempt petitioner,
Contempt petitioner. Contempt, not very.
contempt
Contempt
petitioner,
petition.
petitioner died,
Not contempt.
petitioner died. Mr. Das would like to file an application for substitution of the legal heirs of the petitioner who expired on any date.
My lord, today I got information that date was not
Or
given.
who expired, who is stated to have expired during the currency of the writ petition. The learned counsel for the petitioner submits that the direction of the court was for release of retiral dues to the petitioner. Therefore, these retiral dues after the retiral dues on account of the demise of the petitioner will be payable to the legal heirs of the petitioner. Accordingly, matter will be listed in the month of November, by which date the application for substitution be filed by the petitioner. Yes,
Lordship, the order is at case 8, Lordship. There's some age dispute, Lordship, and they have come with the instruction, Lordship, that he had joined service in 1990, but our contention that he has joined service in 2008. And accordingly, Lordship, that on the last occasion, they were directed to file affidavit. He's a master roll worker, Lordship. And the age dispute is, Lordship, the difference is 30,
what is the direction issued?
Lordship, at case 10, Lordship.
Uh,
Lordship, page 12, Lordship.
Huh?
Page 12.
Page 12.
From the third paragraph, the alleged discrepancy as above with regard to his date of birth obviously requires to be looked into by the authority concerned, and necessary rectification is required to be made so that any incorrect recording of date of birth do not go to prejudice the career prospects of the petitioner. In this regard, the petitioner have brought to the notice the representation dated 27/7/2020 made to the divisional forest officer, Kamru, wherein he has highlighted his grievances.
When is he supposed to retire? As per
Lordship,
the petitioner.
According to Lordship, his date of birth is 1987. And Lordship, he'll retire. According to them, Lordship, he has already retired.
Hmm?
They have stated that my date of birth is 1/3/1956.
Hmm.
And our contention is that our date of birth is 9/1/1987. So almost a gap.
9/1?
9/1/1987.
Huh.
So there is a gap of
So you will retire?
in 2014. 47.
Yes.
Lordship, firstly, we are representing respondent 1 here, not 2. So respondent 1 used to be the PCCF before, but now the incumbent has changed. But at that time, the direction was that he will forward his representation to the DFO. So accordingly, it has been done. And then DFO came, the DFO came with its own conclusion that there are major discrepancies in his application. And at the last moment, at 2020, he submitted a document saying that he's actually younger, and instead of the age.
So the direction is that you will consider the grievances and dispose of the representation. That is the direction.
Yes.
Until it is done, you will continue to pay the monthly salary.
Yes.
So this was disposed of.
Yes.
So the order has been complied with.
Not complied with.
Why?
Our monthly salary has not been paid,
Monthly salary not paid.
not paid.
Lordship, because they retired.
No, no, no. When was the order passed?
Eighteen eight 2020.
When did he retire?
According to them, Lordship, I have retired. Yeah.
Why don't you come up with your instructions, concrete instructions in a proper manner?
Lordship, we have our instructions. We forwarded it to the DFO. And
Have you read this order?
yes, it is there with me. 18/8/2020. The order says that his representation will have to be considered. But at that time, he
With an outer limit of 60 days.
Yes.
When was it considered?
Lordship, according to the DFO submitted his report on 16/10/2020.
So till 1610, you are supposed to pay the salary. Have you paid it?
Lordship, that I'll have to.
Then
Because Lordship, actually, we are just representing respondent one.
what
And-
about number 2, number 3?
We have not received any wakalatnama to represent respondent two. And respondent one has also retired, Lordship. So actually, the incumbent is different.
Notice has not been, steps have not been taken on 3.
No, there are only two contenders, Lordship.
Huh?
Only two.
Is it? Okay. In the writ petition, there were 3.
Yes, in the repeating there.
Okay.
And Lordship, in my.
And Lordship, actually, the salary.
16/9/2021, there is an office note saying that the unserved notice has been returned on respondent 2.
And we have to take press steps.
Then you take fresh steps.
And in the meanwhile, Lordship, that salary, Lordship.
We don't know. That is to be paid by the
By the
DFO. What has he done? There's the direction of the court is very specific.
Right.
Must be the DFO.
Same, একেজন মানুহে আছে,
Mr. S.K. Das appears for the petitioner. Mr. Bothakur appears for the
Respondent one.
respondent number 1. It is submitted that in terms of the court's order, the application was forwarded by the respondent 1 to the respondent 2, who is the DFO at the relevant point in time. As per instructions received, the DFO disposed of the representation, rejecting the claim of the petitioner. On which date was it rejected? Disposed of?
16/10/2020. The report was.
16/10/2020.
Yes.
His representation was disposed of.
Yes. The information was sent to the PCCF, respondent one, saying that
This order was communicated to the respondent number 1. Do you have a copy of that order?
I do not have the physical copy of the writ petition, but I have produced it. Lord.
Stop. The direction of the court, YD, the order dated so-and-so passed in WPC so-and-so was specifically to the DFO to dispose of the representation dated 27/07/2020 filed by the petitioner within the outer limit of 60 days from the date of the order. Stop. As per the communication received from the respondent 2 by the respondent 1, it is submitted that the said order was complied with by disposing of the representation on which date was it?
16/10/2020.
16/10/2020. Stop. Mr. S.K. Das, counsel for the petitioner, however, disputes that the direction also, the learned single judge also directed that his monthly salary be paid, monthly fixed salary be paid without fail till disposal of the representation, which was not carried out by the concerned DFO. Stop. Mr. Bodhakur on the counsel for respondent 1 does not have any instructions. Perusal of the case record reveals that there's an office note dated 16/9/2021, whereby it is recorded that unserved notice has been returned to the office in connection with the notice issued to respondent number 2, which is the DFO. Who is the DFO? Stop. Notices were issued in the matter as far back as 10th of February 2021. It appears that steps have not yet been taken by the petitioner in the correct address insofar as the DFO is concerned. Accordingly, at the request of Mr. Das, the matter, we permit him to take steps, fresh steps on respondent 2.
The new incumbent in office.
We don't know. You take it, whoever you want. Respondent 2 by the next date fixed, list after 4 weeks.
And also, we have not been communicated with the order passed by in terms of.
You first take steps. Your grievances against the respondent 2 is not before the court.
Obliged.
Please, Your Lordship. Your Lordship, there are two interlocutory applications. One, Your Lordship, is for condonation of delay in filing a substitution application, Your Lordship. The other is the substitution application, Your Lordship. We are paying for substitution of the respondent number 1 who had expired in 2020, Your Lordship.
So there is a delay of 310 days.
Yes, Your Lordship.
Okay, heard. Counsel for the petitioner, this is an application seeking condonation of delay of 310 days in filing the application, seeking substitution of the legal representatives, legal heirs of respondent 1 upon his death. Let notice be issued, returnable 4 weeks. Steps on respondents by registered post AD within 1 week from today. MS
Okay, I am appearing for petitioner, R Deka.
R. Deka appears for. Who has filed this application?
Respondent number 1, Your Lord.
Okay, this application is filed by respondent 1. MS R. Deka appears for the writ petitioner T State. Who is the writ petitioner? T State.
Yes, Your Lordship.
Kalanti.
Appears for the respondent so and so. Do you have any objection for the delay? Mr. A. Chakraborty appears for the respondents 2 and 3 state. Since there is no objection to the delay, the court having been satisfied on the grounds urged that the petitioner, that the respondent 1 was suffering from terminal illness and finally passed away on 22/2/2020, and thereby causing immense hardships, including financial difficulties for the legal heirs of the respondent 1. Stop. In that view of the matter, the respondent, legal heirs of the present applicant while taking steps for in terms of the advice of the council for seeking for taking necessary steps for substitution of the legal heirs. Some delay had occurred, delay of 330 days had occurred.
10 days.
10 days. Stop. Where having noticed the grounds urged and upon hearing the submissions of the councils and also taking into consideration no objections being raised by the respondents, the IE stands allowed. Delay of 310 days is condoned. Stop. Registry to list. The other IA is there. IA stands disposed. Number is in it. In that view of the matter, the IA so and so is allowed. Next, in IA number 1878. This IA has been filed by the applicant who are the legal heirs of the respondent number 1 who expired on so and so date. Stop. This application is filed for substitution of the applicant as the legal heir of the deceased respondent number 1. The substitution of the applicants as the deceased legal heirs. Stop. By order dated 13/10/2023, passed in IA 1877 of 2023. This court had condoned a delay of 310 days that had occurred in filing the IA. Stop. In that view of the matter, let notice be issued, returnable 4 weeks. Any objection?
Okay, we have no objection.
Any other person not represented? All are represented.
Yes, your lordship.
All right, then MS Das appears for the respondent petitioner, Mr. A. Chakraborty, for the state respondents. Learned counsels appearing for the respondents do not object to the prayer made for substitution of the legal heirs. In that view of the matter, the IA stands allowed. The applicants, namely 1, 2, and 3, are permitted to be substituted in place of the petitioner, late Omal Tati, who expired on so and so date. In that view of the matter, the IA stands closed. The petitioner, the applicant will file amended course title before the registry within 1 week from today. In WPC so and so, you write, in view of the order passed in IA 1878 of 2023, applicants 1, 2, and 3 are substituted in place of the writ petitioner,
Respondent number 1, your
respondent 1, as respondent 1 so and so Omal Tati, who stated to have expired. Petitioner is directed to file amended course title within 1 week from today. Matter be listed pursuant to the filing of the amended course title and endorsement, necessary endorsements being made by the registry. List in the month of November.
Lastly, interim order, there is an interim order that may be continued.
that was not continued earlier, your lordship. But anyway, we're not getting it.
There's no extension of interim order. Not extended. Not rejected, but not extended. Let it be like that. Whatever is there. If you want to extend an interim order, you file proper application. Yes.
Most of it.
My lord, I'm on behalf of SMC District, your lordship.
Huh?
I'm appearing on behalf of SMC District, correspondent number 2, your lordship.
What happened?
Matter may be adjourned for today, your lordship.
Why?
Need to get some more instructions, your lordship.
All right.
My due is from 2005 to 2010, that ABR salary, and they have admitted, they have also sent proposal, but
After vacation?
can it be on Tuesday? Lordship? Because
Wednesday. List on Wednesday. 18. As it is submitted by MS and so that the council appearing representing respondents is not available in court for the day. Mr. S.K. Das for the state, for the petition. Yes.
Okay.
In terms of the adjournment request circulated, matter stands adjourned for 2 weeks. We listed in the month of November.
May it please your lordship. Lordship, in this case, lordship, the SLC has rejected the prayer of the compassionate appointment of this petitioner lordship on the ground of overage lordship. That was not lordship raised by the DLC lordship. Because his father was expired on 30/11/2016.
Yes, instructions
Lordship, that instruction received lordship.
stating
Overage lordship, as per the constable is concerned, it is age limit is 25. lordship.
age limit 25.
25.
How old is he?
No,
26 years.
Huh?
26 years and month.
On which date?
The date of application, date of application. Date of application 7/2/2017. And the application on 2020 lordship, that is his age is 28 years in the affidavit lordship. Lordship, as per application that is on page 9 lordship, date of birth given lordship 9/8/1991 lordship. Page 9 lordship.
Yes. So you are overage.
That was not considered lordship. That was SLC lordship has rejected. He may be allotted in other post lordship because he is not seeking for that UB post lordship.
You consider his case in terms of the clause 15 in case of any other vacancies available. You consider his clause case.
Remand back the matter to SLC lordship.
Okay, heard learned counsel for the petitioners, Mr. Chaudhary, Mr. Chakraborty for respondents.
Number.
This application is filed by the petitioner praying for a direction to the respondent authorities to consider his case for appointment under compassionate scheme. Para the petitioner's late father
Jayajuddin Ahmed, page 9.
so and so died in harness on 30/11/2016 as he was working as an UB constable under Superintendent of Police, Borpeta district. Being one of the legal heirs, the petitioner filed his application on 14/7/2017 for consideration for appointment under compassionate scheme. Stop. The DLC.
Page 12. Lordship.
When did you file your application?
Lordship, the application filed on lordship 7/2/2017 lordship.
Application was filed on 7/2/2017. And the DLC considered the case of the petitioner by its meeting held on
14/7/2017. Page 12 lordship.
2017, whereby the name of the petitioner was recommended for. Where is the name of the petitioner?
That is lordship on page 13, petition number 3 lordship. Page 13 lordship, candidate name recommended lordship. Rabiul Uddin.
Was recommended for being eligible for appointment, recommended the proposal for appointment to the vacant post of unarmed branch constable in the year 2015. Stop. This proposal, however, came to be considered by the SLC. And the SLC, by its minutes held on 28 June 2018, rejected the case of the petitioner on the ground that he was overaged for the constable, for the post of constable. Stop. Where Mr. Chakraborty, learned government counsel, submits on instructions that the cutoff age for constables is 25 years on a date of consideration. Stop. The petitioner, in his application, which is available in the part of the pleadings, stated that his date of birth is 9/8/1991, and the application was submitted on 7/2/2017. As such, on the date of the submission of the application, he was more than 26 years old. And accordingly, the SLC had rightly rejected the case of the petitioner. There is no infirmity in the minutes of the SLC. Therefore, the same does not call for interference. Stop. Para. Having heard learned counsel of the parties, it is seen that the directions, it is seen that the proposals for consideration of appointment under compassionate scheme is governed by the circular 16/2015, which was the, not circular, OM, which was the OM prevalent at the time when the case of the petitioner was considered. Stop. Under clause 15 of the OM, it is provided that if the case of the petitioner could not be considered in respect of vacancies not being available, then the administrative authority will make inquiries to find out the availability of vacancies in other administrative department to see if the petitioner's case can be considered. Stop. The application submitted by the petitioner does not reflect that he had applied only for the post of unarmed branch constable. Stop. As such, the respondent authorities who had considered the proposal, as such, the SLC, which had considered the proposal, was required to consider the proposal of the petitioner also in context of clause 15 of the said OM dated so and so. Stop. The minutes of the SLC upon due perusal does not reflect that the SLC had considered the case of the petitioner keeping in mind clause 15 of the OM dated so and so. Stop. It is possible that in the event there are vacancies available, the petitioner could have been considered for appointment on the compassionate ground, notwithstanding that he was considered overaged for appointment to the post of constable. Stop. Under such circumstances, this court is of the view that the writ petition can be disposed of by remanding the matter back to the SLC to reconsider the case of the petitioner in respect of any other vacancies that may be available, keeping in view the provisions of clause 15 of the OM dated so and so. Stop. In the event the SLC finds that petitioner's case could have been considered for any other vacancy, towards any other vacancy, then necessary orders will be passed, which will override the order, which will override the proposal of the petition of the SLC. Sorry, we override the minutes of the SLC held on 28 June 2018. Insofar as the writ petitioner is concerned regarding rejection of his proposal for being overaged for the post of constable. Stop. The SLC will consider the case of the petitioner in the next meeting to be held by the SLC. Stop. A copy of the, now with the above observation, writ petition stands disposed of. Copy of this, copy of the, when is the next meeting likely?
Don't know, Lordship.
SLC?
It's held in every 6.
The, who will place it before SLC?
In the past SLC.
Who will place it before the SLC?
DLC placed the DLC placed it.
Who is the chairman of the DLC here?
Deputy Commissioner Lordship. Deputy Commissioner is the
Borpeta.
Borpeta, Lordship.
The Deputy Commissioner Borpeta is therefore directed to place the proposal of the petitioner again before the next DLC, the next SLC that is scheduled to be held for reconsideration in terms of the directions passed in this order. Stop. With the above observation, writ petition stands